May please, Your Lordship. I beg to mention for listing an item, my lord, on after vacation, my lord, on 21st of April, my lord. Obliged.
May I please, Your Lordship? I beg to mention item number 33 of this daily list.
What do you want?
My learned senate is out of station and we have submitted.
What do you want?
We want it to be listed after
We are for whom? We are for whom?
we are for the petitioner.
On the prayer of learned counsel, Mr.
B. Yadav.
B. Yadav appearing for the petitioner. Admission hearing of this matter stands adjourned for 2 weeks. List accordingly. Item 33. Yes.
My lordship, my lord, I pray for listing of a motion matter tomorrow or day after tomorrow, my lord. The subject matter is that, my lord, the petitioner has been sought to be ousted from service by replacing the private.
Day after tomorrow. Day after.
Obliged, my lord.
May it please your lordship. My lord, there is a petition of 2016. It was last listed on January 2022. May I pray that matter may come up for admission hearing sometime in the month of June or May last week, my lord.
June. You make you mention for June.
My lord, it needs to be hard, that's why, my lord. Or May in the last part of May, my lord.
Let it be listed for orders first.
My lord.
After view orders. Yes.
Lordship, I beg to mention an urgent matter for motion.
Hmm.
But there has been some computer typists of the Chief Judicial Magistrate establishment wanted to participate in a promotional process. In spite of the notification given by the High Court of equivalency with LDA, now there is an order corrigendum passed that we are not eligible. Last date is 12th of April, Lord.
Let it be day after tomorrow. We'll see if any orders. Day after.
Lord, another matter relating to selection and selection of Gaon Pradhan, Lordship. The DC has selected, Lordship. We have challenged the selection of 2 private respondents. Therefore, Lordship, day after tomorrow.
No, that it can wait. 19th we'll take it up. 19th.
And
That can
Lordship, if appointments are made, Lordship.
Appointments are made. If it is found to be illegally done, it will be set aside. 19th. Yes.
Lordship, I beg to mention item number 15.
Yes.
I have taken the consent from the other side. Matter will be taken up after 2 weeks, Lordship.
Okay. Item 15, with the consent of opposite party, learned counsel appearing for the, you are for the
Read petitioner.
read petitioner, Mr. D. Chaudhary, 6 posting of these matters again after 2 weeks. Prayer allowed, list the case accordingly.
Obliged.
I beg to mention for listing of a hearing matter, my lord, pending since 2014. My lord,
When? First, get it listed for orders, then we'll fix it.
my lord.
Orders after vacation, orders.
Obliged.
May I please, Your Lordship. Lordship, I may be allowed to move on read petition. It is relating to compassionate appointment. DLC is selected, but thereafter no action has been taken.
19th.
May I please, Your Lordship? I beg to mention item number 2, Lordship. The matter may come after vacation, Lordship. I am for the petitioner, Lordship.
As prayed for by learned counsel for the petitioner, this matter stands adjourned for a week. Yes.
Obliged.
May I please, Lordship, item number 14, Lordship, in this case, Lordship, I have filed affidavit in opposition. That may be called for, Lordship. I will do it.
Yes.
May I please, Your Lordship, I beg to mention for listing matter for the admission. Last occasion dated was 14th March 2023.
First week of May, put a date, first week of May. Yes.
My petition was last heard on 1st of March, and it was moving forward as the notice was to be served to the respondents, and the concerned standing council of the FCI was supposed to furnish the addresses of the respondents within 2 weeks. I have not received this. Now it is 6 weeks past.
You find out from the registry why it has not been done?
No,
What do you want? What do you want today?
It was to be submitted to me by the Standing Council of Food Corporation of India within 2 weeks. That means within
They have not done it.
they have not done it.
All right, we'll go and meet him and ask why he has not done it. What is the order you want?
One that next order should be for the summons will be notices will be served by the department.
Today only that order you want. Where is the file? It cannot be done.
No, next date can be given.
Yes. After in the first week of May.
First week of
May.
Let's say I beg to mention item number 20. The matter may be taken after Bihu holiday.
Item 20, passed over, list after view only.
Senior council is out of station.
It's prayed for by petitioners council, matter stands passed over.
Mm.
List after view.
May please, because I pray for listing or revision for withdrawal. Lordship. Tomorrow, Lord. Oblige, Lordship.
Maybe Lordship. Lordship, I pray for the withdrawal of writ petitions, my lord. As per the convenience of.
Tomorrow, day after, you put it.
My-
in date, yes.
May please, your lordship. Lordship, item number 43, lordship, may come after 3 weeks, lordship. I have challenged the rule in the division bench, lordship, pertaining to the same matter.
All right. As paid for by Mr. M. Bhagavati, learned counsel for the petitioner, this matter stands adjourned for 4 weeks. List
Lordship.
accordingly.
Lordship, I have another prayer for listing, lordship. I filed an IA, lordship, on 31st March, lordship. It is urgent, lordship, may be fixed day after tomorrow, 12th.
What is the urgency?
Lordship, because some process is going on for promotion, lordship. But they say that since it is case has been filed, lordship, and it is sub judice, so we are not considering your cases. So I just want a simple order that pendency of this case will not be a bar. Much obliged.
My lordship, I beg to mention for listing admission matter was last posted on 9 Jan.
First week of May, first week of May. Yes, next matter, please. First week of May. You put a date, first week of May. Yes,
Please, your lordship, this matter may be listed for motion on 12/4. Your lordship, this matter relates to family pension.
19th, you put the date of 19th, yes.
Next. May I please, your lordship? I filed an IA to modify an order regarding village headman passed by your lordship in a dispose of writ petition without hearing me, which has caused an injury to me, so the IA may be listed tomorrow.
19th. 19th. Yes.
Promotion item 1.
None appears for the petitioner. The learned counsel for the petitioner has remained absent even on 2 consecutive occasions in the past. Full stop. Ms. S. Sharma, learned standing counsel, held
PWD
PWD
for all the respondents.
is present on behalf of all the respondents. Full stop. Since the petitioner has remained absent consecutively on 3 occasions, it is apparent that the petitioner is not interested to pursue this writ petition any further. As such, this writ petition stands disposed of for non-persecution.
Item 3 to 5.
In terms of the last order, but I think they were supposed to bring the instructions.
Lordship, will file affidavit, lordship.
The instructions on what?
But why this has not been paid, the minimum pay scale has not been paid in spite of a specific order of the court. That order your lordship will find at page.
So you have received instruction.
No, lordship, will file affidavit. Affidavit, lordship.
No, without instruction, how will you file affidavit?
Lordship will receive instruction, lordship.
Actually, they have told you that they will give you instruction. I don't understand what is the submission. Mr. Court, these matters cannot be sorted out in motion. We'll issue notice and fix it on a date, by which time if they don't file affidavit, we'll proceed and decide.
But there is already an order of the court. That's why some contempt matters are also tagged, I think. So,
Then we'll adjourn it by 2 weeks.
yes,
This
madam.
cannot be.
Yes, madam.
Uh,
First week of May, any day.
Mr. B.D. Cole, and Senate Council is present on behalf of the petitioner. Miss, your name, please?
R. Gogoi.
R. Gogoi, learned standing council, APDCL. Submits that another 2 weeks time be granted to seek instruction and file affidavit. First of Miss M.D. Boral and Government Advocate Assam is present on behalf of the state. On the request of Miss Gogoi, this matter stands adjourned for 2 weeks. These matters stand adjourned for 2 weeks, list accordingly.
My lord, may I pray for a day on 8th of May, my lord?
Not 8th of May, 10th of May, list again on 10th of May.
Deeply.
Item 6.
Me, please, your lordship. I appear for the sole respondent, your lordship. I would rather like to place a document, your lordship. Your lordship, it goes to the letter, your lordship, dated. Second last paragraph, your lordship. The direction was to place the case of the petition before the SLC, your lordship, but the letter says it could not be placed, your lordship.
All right, then we'll close it. Next
Yes,
SLC, they'll place it.
Yes, your lordship.
Yes. Heard, Mr. Swain, Direct Counsel for the petitioner alleging willful disobedience of the order dated 27/7/2022 passed by this court in WPC number 6519/2018, whereby a direction was issued to place the case of the petitioner before the next SLC. This contempt petition has been filed. On instructions obtained from the concerned official, namely Deputy Secretary to the Government of Assam, Establishment B Branch bracket Confidential Cell bracket close PWRD, Dispur, Mr. A. Das. You are government advocate.
No, your lordship. I
Okay.
appear for the sole respondent, your lordship.
Mr. A. Das, appearing for the sole respondent, has produced a copy of the written communication dated. What is the date of it? 4th of April 2023, which goes to show that due to unforeseen circumstances, the case of the petitioner could not be placed before the SLC. However, the instruction dated 4/4/2023 indicates that his case will be placed before the next meeting of the SLC. In view of the above, by retaining a copy of the written instruction dated 4/4/2023 in the record of this case, this contempt case stands closed. The petitioner would be at liberty to approach this court once again, as and when a proper cause of action arises.
Oblige, your lordship.
Yeah, please, Lord.
Yes.
This is a contempt petition that please, my lord. Page 163, my lord. 163, my lord. Serial number, my lord, 3. Upon receipt of the amount bills of the writ petitioner shall be processed and cleared within a further period of 45 days, my lord. I'm not, my lord, getting my payment, my lord. I have submitted representation, my lord, at page, my lord, 165, my lord.
Alleging willful disobedience of the order dated 27/9/2022 passed by this court in WPC number
207, my lord, 892, my lord, WPC, my lord.
WPC number
892 of 2022. 892 of 2022, my lord.
Common judgment and order dated 27/9/2022 passed in WPC number 892 of 2022 and the batch of connected writ petition. This contempt case has been filed. I have perused the statements made in the what you heard, Mr. SSS Rahman, Learned Counsel for the petitioner. Perused the statements made in the petition. Issue notice returnable in 8 weeks. Petitioners to take step for service of notice upon the respondents by registered post with AD.
Your Lordship, here in this writ petition, we have challenged the extension of the suspension order on the ground that it was not done within 90 days period. The respondents, they filed an affidavit to the effect that since the suspension order, original suspension order was served upon me on 7th of November, that's why the date of effective order is 7th of November. So they claim that the review was done within the 90 days period. Now, if we have to actually apply that particular analogy, Your Lordship, then to that effect, the extension order, the extension of the review order, which was dated 3rd of February, I received it on 12th of February. So that again would mean that the date of effective order would be 12th of February. Even then, if it is considered that way, then also it is not done within a 90 days period. And to that effect, I just want to place this particular DOPT office memorandum, which says that the date of effective order would be mentioned in the suspension order itself. Now, if your Lordship peruses to page number 104 of the writ petition, therein the suspension order states that it is with immediate effect. Now, in this particular OM, last paragraph, para number 4.
So what have they stated in the affidavit?
They have
Well,
stated that
as per on this honorable court, last order, my lord, directed to file an affidavit, as per our, my lord, we hand over this order, my lord, on 7th of November, my lord. And this honorable court directed to file an affidavit to that extent, my lord. And accordingly, we filed an affidavit. My lord.
What about his application seeking leave?
My lord, yes, my lord.
that is also they have issued a
Mr. Bora, take your seat.
I'm sorry.
Take your seat.
My lord, it was rejected, my lord. There is speaking order passed, my lord.
Speaking order has been passed.
Yes, my lord.
Okay. So do you want to
So-
file any rejoinder?
yes, rejoinder to this particular affidavit which they have
You
filed.
want to file? Then why are you arguing on merit? How much time you want?
2 weeks, Your Lordship, immediately after vacation.
And other day, my lord, they filed another petition, my lord, which was withdrawn on dismissed, my lord. And regarding the memorandum, the article was issued, my lord, to file a written statement. Until date, they have not filed written statement, and that was issued on 10th of March itself. And my lord, writ petition was dismissed by this honorable court also.
Have you got a copy of this order, 5th April 2023?
Yes, yes, so we have disciplinary proceeding has started. We have filed actually, I don't know where he got his instruction, but we have submitted a written statement of defense. That is a different issue altogether. But I am here on the technicality part of the suspension order. That I have withdrawn because interim protection was sought for, and since
You are appearing for all the respondents.
Yes, except, my lord, my friend, my lord, National Higher Authority of India, my lord.
For respondent number?
It was five, my lord. 5 and 6.
5 and 6. 5 and 6, Lordship. RK Talukder appeared.
All right, then let us issue notice.
Yes, my lord, notice.
You file a rejoinder.
Yes, my lord.
Heard Mr. D. Bora, learned counsel for the writ petitioners. Also heard Mr. S.K. Mehdi, learned counsel, CGC appearing for the respondent numbers 1 to 4. Peruse the affidavit filed by the respondent numbers 1 to 4 on 5/4/2023. Mr. Bora prays for 2 weeks' time to file a rejoinder. In respect thereof, full stop. In view of the above, issue notice of motion returnable on 12th of May 2023. Since Mr. Mehdi has accepted notice for respondent numbers 1 to 4 and Mr. R.K. Talukder, Learned Standing Council. This is what, National Highways, is it? Learned Standing Council, National Highways and Infrastructure Development Corporation Limited, bracket NHIDCL, bracket close, for respondent numbers 5 and 6. No formal notice is required to be sent in this case. Extra copy of the writ petition be furnished to the learned departmental council so as to enable them to departmental council full stop. This case again on 12/5/2023 for admission.
Yeah, Lordship, with regards to the leave portion, I have been confined to my quarters. They have passed this speaking order. They have not stated any ground as to why my leave should not be granted.
Challenge it,
Yes, my lord.
challenge it.
My proceeding is continued, started, my. 12.
You have got a copy of this
Uh,
this order? Have you got a copy?
of the memorandum of charges, your lordship, yes, I believe, yes.
5th April order by which your application has been rejected. Have you got a copy?
Yes, yes, yes.
Last occasion, my lord, this honorable.
Already-
My lord.
We was directed to obtain instruction whether GLC has considered his case or not. But I have gone through it, my lord. He initially applied for the sectional assistant. Sectional assistant required higher secondary science, to for knowledge, my lord. And he is a matriculation. And thereafter, a PhD department has their said for fourth grade department. Instruction is necessary, my lord. 4 weeks time may be granted, my lord. I will obtain.
Heard Mr. M. Kalital and counsel for the petitioner also heard Mr. T. C. Chutia, learned additional senior government advocate Assam appearing for the state who submit that since the petitioner was not qualified for the post of sectional assistant, hence instructions would be necessary so as to ascertain as to whether he can be accommodated in any other post. As such, 4 weeks time has been prayed for. Full stop. You should notice the motion returnable in 4 weeks. Since Mr. Chutia has appeared and accepted notice on behalf of respondent number,
That's number 6, my lord.
respondent number 6, Mr. R.S. Musahari, R.K. Musari for
4, 5, and 7.
respondent numbers 4, 5, and 7, and Mr.
SM Hassan, lord.
S.M. Hassan,
2 and
learned,
Owner number 2 and 3.
learned standing council PHE, Department Assam for respondent numbers 2 and 3. Why you can't accept notice for government, chief secretary?
Chief Secretary, I can accept.
Ah.
Yes, yes.
TC Chutia 1 or the go. 2 and 3. Service of notice is deemed to be complete in this case. Extra copies of the petition be furnished to the learned department council so as to enable them to obtain instruction facilitating disposal of the writ petition at this stage of admission hearing.
Obliged.
That SK Mediwala case.
Matter relating to the appointment and selection of Gram Pradhan, my lord. The petitioner, my lord, appeared in the post, my lord, for the selection of the Gram Pradhan of the SARS 15 Sengar Revenue Cycle under Barpeta district, my lord. He is the family member of earlier, my lord, Gram Pradhan, my lord. That was not considered, my lord. Also, the respondent, private respondent is not a local person, my lord. He had under the conditions, my lord, advertisement, he must has landed property in that area, my lord. And
Have
again,
you preferred appeal?
No, lordship.
no, my lord,
You go and prefer appeals. That is this standard order we are passing in every case.
Lordship.
All right. You take down, heard Mr. Respond number 4, is it?
yes, one remark for my private respondent.
You take down. Heard Mr. S. Sekel, and counsel appearing for the writ petitioner. The petitioner was an aspirant for appointment to the post of Gao Pradhan in charge number 15 of village Borbhita under Senga Revenue Circle in the district of Barpeta, Assam. Full stop. However, he has not been selected. Full stop. Assailing the selection and appointment of the private respondent number 4 in the post of Gao Pradhan, the instant writ petition has been filed internally alleging that the respondent number 4 did not fulfill the eligibility requirement under the advertisement notice dated 3/9/2022. Full stop. Mr. Saikia submits that the respondent number 4 submits that the selection of respondent number 4 is contrary to the conditions of the advertisement notice. Full stop. At this stage, Mr. J.K. Goswami, learned government advocate Assam, submits that since these orders are appealable under regulation under rule
Executive instruction.
160 under
162C.
under rule 162 bracket C
Lordship.
of the executive instructions framed under the Assam Land and Revenue Regulation, 1881, the petitioner
1886.
1886, the petitioner should be directed to avail alternative remedy, full stop. In view of the above and considering the facts and circumstances of the case, his writ petition is being disposed of by granting leave to the petitioner to prefer an appeal under Rule 166, 162C
C.
before the jurisdictional divisional
Lower
commissioner.
Assam Commissioner.
If such an appeal is filed within 10 days from today, along with a certified copy of this order, the same be looked into and disposed of by a reasoned order after
Okay.
hearing the affected parties. Mr. S. Datta, Learned Standing Council, Revenue and Disaster Management Department, Assam, is present.
Item 12.
May it please your lordship, my lord, before my learned friend start, my lord.
Hmm.
The state had preferred an appeal, my lord, but the appeal is yet to be listed, yet to be numbered, my lord.
Preferred an appeal against?
Again, the order dated 31/2023 of the learned single judge.
Where is
Three.
that? Where is that order?
Order is in the last
Number 41, my lord.
41.
41.
my lord. Start from 41, my lord.
Where is the operative part?
My lord, 45 number, my lord, page number 77, my lord.
Hmm.
Paragraph 19.
So you preferred an appeal.
My lord,
So what to do? We'll adjourn it for 2 weeks.
my lord.
Yes. Heard Mr. D. Gogoi, learned counsel for the petitioner. Also heard Ms. M. D. Bora, learned government advocate Assam, and Mr. N. Upadhyay, learned SC Irrigation Department Assam, who submits that the petitioner is seeking the benefit of judgment and order dated 30/1/2023, passed by the learned single judge in WPC number 1646 of 2021. But since the state has preferred an appeal against the judgment, this matter be deferred for 2 weeks so as to enable her to obtain further instruction in the matter. Post a prayer allowed. List this matter for motion after 2 weeks.
I'm deeply obliged. The matter of compassionate appointment, my lord.
Hmm.
Petitioner is a minor at the date of time of his father, but he is not entitled.
None appears for the petitioner on call. Miss M. D. Boral and government advocate Assam is present on behalf of the state.
All the respondents.
On behalf of the respondent, since the petitioner's counsel is absent today, this matter stands adjourned for a week.
Deeply obliged.
Supplementary list for motion item 60.
My lord. A compassionate appointment, my lord. Initially, my lord, 2 times, my lord, rejected by the DLC, my lord. A petitioner accordingly approached before this honorable court, my lord. Court directed the respondent authorities to place the name of the petitioner, my lord. Accordingly, my lord, a DLC selected and recommended as a junior assistant in a high school, my lord. But state level committee, my lord, without placing the matter, my lord,
State level.
communicated some order, my lord.
Reject state to states. Lordship.
Hmm.
Lordship, SLC had rejected, according to the petitioner, your lordship,
Not
SLC
rejected. Not placed.
not placed. But then in paragraph 8, your lordship, it has been stated that SLC has rejected his claim.
Hmm. You take proper instructions, miss. You are
Not
appearing
take-
for whom?
For secondary education department, your lordship,
Then you obtain proper instruction. Let
Lordship.
us issue notice at this stage.
lordship.
Take down hard, Mr. A.M. Ahmed, learned counsel for the petitioner, agree by non-consideration of his case by the SLC for appointment on compassionate ground. The petitioner has approached this court by filing the instant writ petition. Full stop. Miss, your name, please?
D. Musahari, your lordship,
E. Musahari, learned standing counsel.
for secondary education.
Secondary Education Department,
Department.
Assam, seeks 4 weeks time to obtain instruction and respond to the allegations made in the writ petition. Full stop. In view of the above, issue notice of motion returnable in 4 weeks. Since Ms. Bushari has appeared and accepted notice on behalf of all the
Lordship.
respondents.
Not all, your
Then-
lordship, because state is also there, your lordship.
You are for whom? Tell me.
Lordship for respondent number 2, 3, 4,
You are appearing for the
6.
chief secretary.
Lordship for.
Oh, write like this, respond numbers
Lordship for
3, 4, 5,
3,
and
4,
6, and Miss and Mr.
and
J.P.
for 6
Goswami,
also.
learned government advocate Assam for respond numbers 1 and 2. Service of notice is deemed to be complete in this case. Extra copies of the writ petition be furnished to the learned department council so as to enable them to obtain instruction.
Obligation.
Item 51.
Yes, please, Mr. Lordship. Lord, 51 to 55 are similar, my lord. Age relaxation is the issue, my lord. My lord, we were appointed as medical officer. Thereafter, we were placed at the Ayurvedic College and to discharge the functions of a lecturer, my lord. Now we had rendered our services for 7 years continuously. Now they've advertised this post. Now, by this time, we've exceeded the age limit. So we want a relaxation on the ground of fair dealing, because your lordship is aware of the notification of 81, my lord. So, my lord, we had applied. In fact, the director of Ayush had also recommended for age relaxation. But now, my lord, nothing has come up. So by this time, my lord, 13th is the last day for submission of the application forms. My lord.
My lord, I have obtained the instruction that their application has been put up, my lord. Put up in the file for consideration, my lord.
My lord,
But the time is very less.
Yes, my lord.
no, the difficulty is it's an online process, my lord. The moment we enter our date of birth, it doesn't accept, my lord. The system doesn't accept. So physical applications are permitted.
That may be done, my lord. They may be allowed to submit physical application, and in the meantime, if their applications are considered, and if it is accepted, my lord, then they will participate, and if it is rejected, my lord, then it will take its own course, my lord.
But how will they know? Then you will say the date is over.
No, my lord.
So you
The
now,
last date of the submission of application is 13th. 13th.
1/3.
1/3.
All right. So you accept physical
Yes, my
applications
lord.
from them.
That is I am saying, let them submit physical application. So in the meantime, their application for age relaxation will be considered, because that has already been put up in the file, my lord. So
we can dispose of this writ petition.
yes, my lord.
Huh?
Very well.
We'll dispose it on. All right. Heard Mr. B.D. Deka, learned counsel appearing for the writ petitioners in this batch of writ petitions. Also heard Mr. D.P. Bora, learned standing counsel, Health Department, Assam, appearing for the respondents. Full stop. The grievance of all the petitioners in this batch of writ petition is common, and therefore these matters are being taken up for disposal by this common order. Full stop. The who had issued the advertisement?
Lord, the Medical and Health Recruitment Board. my lord.
MSRB, Medical and Health Recruitment Board.
Where is the advertisement?
Page 37. my lord.
Page 37.
37. Lord, our post of assistant professor, your lordship finds at page 42, my lord. 45 is the age limit. 202.
And why are you seeking age relaxation? Because
We've been rendering services as assistant professor because we were initially inducted as medical officers, but since 2013 to 14, my lord, we have been discharging functions.
so you are continuing to serve, but your services are not regularized.
Not regular.
All right. The Medical and Health Recruitment Board, Assam, had issued an advertisement notice dated 16/3/2023 for filling up the post of assistant professors on regular basis. Full stop. All the writ petitioners who were appointed
As medical officers, subsequently promoted as senior
medical officers and subsequently promoted as
senior medical officer.
senior medical officers are presently discharging duties as assistant professors on temporary basis. Full stop. The petitioners are desirous of participating in the recruitment process pursuant to the advertisement notice dated 16/3/2023. But since they have exceeded the age of participation as notified in the advertisement, they had submitted representations before the concerned authorities seeking age relaxation. Full stop. However, according to Mr. Deka, no action has been taken on such representations till today. Full stop. Mr. Deka has also pointed out that the last date of submission of application is 13/4/2023. And since these are all online applications, the system is not accepting the applications of the petitioners due to the age bar. Full stop. Responding to the above, Mr. Bora, Learned Departmental Counsel, submits that the representations submitted by the petitioners seeking relaxation of age have been put up in the file, and the matter is under active consideration of the competent authority. Full stop. A decision will soon be taken on the applications submitted by the petitioners, on the representations submitted by the petitioners, and if the same is accepted, they would be allowed to participate in the recruitment process. Full stop. Taking note of the submission made by both the sides and having regard to the peculiar facts and circumstances of the case, these writ petitions are being disposed of by providing that since the last date of submission of application is 13/4/2023, and considering the fact that the online system is not accepting the applications, proposed applications sought to be submitted by the petitioners in online mode, all the writ petitioners would be permitted to submit application in physical form on or before the last date of submission of application, on or before the last date, that is 13/4/2023. Full stop. The representations for relaxation of age as submitted by the petitioners shall be considered and disposed of with a reasoned order on or before the date fixed for holding the selection process.
Yes.
Full stop. If the petitioners, in doing so, the authorities would consider the long years of service already rendered by the petitioners, and the fact that there is very limited scope for them to seek employment elsewhere. Full stop. On the conclusion of the aforesaid exercise, if the petitioners continue to remain aggrieved in the matter, it shall be open for them to approach this court once again by filing appropriate writ petition. With the above observations, these writ petitions stand dismissed.
Manoj, there's just one clarification. There's one particular writ which is 2031, Manoj.
Mm.
There the online copy has been accepted.
Mm.
But she's from the OBC category, but because there was a corrigendum issued that age relaxation may not be applicable. So for her, Manoj, perhaps physical copies, applications may not be necessary.
Then you take out that,
Manoj.
that which is the case number?
2031.
2031 is separate order, similar thing, except
She may
online.
be
not-
allowed to participate, that's one.
In that case, online, that part physical is not required. She will be allowed to provisionally allowed to participate in the recruitment process. She belongs to
No, no,
OBC
no.
category.
So her application has been accepted, so her age relaxation application will be considered, my lord.
Her application belongs to OBC category candidate, and her application has already been accepted to the online mode. But the representation for relaxation of age is still pending. The petitioner be, no, then rest will be same.
Yes,
Before- Rest will be same. Before holding the recruitment process,
Yes, my lord.
selection process,
Yes,
application, representation to be considered and disposed of. Yes.
Obligation, good.
This you type out a separate order. Yes.
Orders.
May it please your lordship. Oh, my lord, we have filed this IA for vacation of an interim order, my lord.
Hmm.
In fact, lordship has dealt with similar matter, my lord. What had happened,
There was a selection for the post of chief engineer, my lord, in the water resources department. Irrigation, irrigation department, my lord. And my lord, my learned friend's client, who is a reserve category candidate, my lord, his position was altered in the seniority list by application of that 18-123 OM. But notwithstanding that, my lord, he is in the zone of consideration. And in fact, his case was considered also. But on merit, my lord, his case has not been recommended. My lord, if your lordship kindly takes the IA, my lord.
Yes. Which is the order you're seeking?
Yes, the order is at my lord, page number 49, my lord. No, my lord. Oh, hi. 49, and the operative portion is at my lord, page number 54. Considering the submission made by the learned counsel for the parties, and upon hearing the respective counsel, this court is of the view that state need not be restrained at this stage from proceeding with filling up the vacancies which are likely to arise, as he has been submitted after 31/3/23 upon superannuation of the present incumbent. However, any such proceeding relating to selection and promotion of fresh incumbent for the post of chief engineer irrigation that may be undertaken by the state with regard to the post of chief engineer irrigation may not be finalized without leave of this court. My lord, the selection has taken place. In this selection, my lord, the present applicant is at serial number 2. My lord, the person who was at serial number 1, he was appointed and he retired on 31/3/23, my lord. Now the fact of the matter is, I am due for promotion, my lord. I have been recommended. Your lordship should kindly come to paragraph 8, my lord. They have made that statement. At page 10, that the selection committee meeting was held on 16/3/23 to fill up 2 number of posts of chief engineer minor, and chief engineer major, as well as for expected vacancy of C. Onu Borua, respondent number 4, in the writ petition, is going to retire from service on 31/3/23. Accordingly, selection committee has considered altogether 8 number of additional chief engineers from the gradation list of additional chief engineer published on 4th of March 23, and merit with due regard to seniority being the only criteria, the writ petitioner's position being at serial number 8 in the gradation list, and writ petitioner is also under the zone of consideration for the 2 posts of chief engineer, and merit with due regard to seniority being the only criteria in the selection to the post of chief engineer, position in the gradation list has no role to play. Now, the case of the writ petitioner was, my lord, that earlier he was above. Now, following 18-123, my lord, OM, his position has been altered now because catch-up principle has been applied. Now, in any case, my lord, he is not aggrieved, because right to be considered for promotion is a right, and he has been considered. And in fact, lordship has exactly on similar point, my lord, lordship has passed this order, my lord. This Orup Jyoti Borthakur's case, my lord. Ekhon diok na. Exactly on the same point, my lord. It was pertaining to, my lord, Water Resources Department. If your lordships will kindly come to, my lord, the last page 5, last sentence. This court also finds sufficient force in the submission of Mr. Mojumdar, learned AG, that petitioner having been considered along with other eligible candidate, the impugned OM dated would not have any relevant bearing in the case quad writ petitioner. Last sentence, my lord, at page number 5.
Yes.
This court finds sufficient force in the submission of Mojumdar learned AG, that petitioner having been considered along with the other eligible candidate, impugned OM dated would not have any relevant bearing in the case quad writ petitioner. This court is also conscious of the fact that applicant is one of the candidate in the zone of consideration and he is due for retirement from 31/1/23. Therefore, there can be no doubt about the fact that if an interim order dated 25/1/23 is continued in the present form, then in that event, there is a strong likelihood that it would cause irreparable injury to the interest of the applicant. Situated thus, considering all other facts and circumstances of the case, this court is of the opinion that the interim order passed on 25/1/23 needs to be suitably modified. Because, my lord, the writ petitioner, there are two posts of chief engineer. Zone of consideration, there are 8. His number is serial 8 in the revised seniority list. So he has been considered. So, my lord, the senior alteration of the seniority,
How many? 3 posts?
2 posts, my lord.
2 posts, and how many have been considered?
8, including the writ petitioner.
And the
And he has
criteria-
not been recommended. Because the criteria of promotion is merit with due regard to seniority.
So seniority position, he has come down.
Come down because of the, my lord, new OM
18-1.
18-1.
But if the 18-1 is set aside, then. his
Then,
position-
then also, my lord, he will be considered. If it is not set aside, then also he will be considered because he is within the zone of consideration. So really to decide this as case, my lord, my learned friend will have to now challenge the DPC minutes and the consequential promotion that he has not challenged.
Yes, Mr. Das.
DPC we have challenged, my lord.
You have
My
challenged
lord,
in
I'll
this.
just point out. My lord, I'll trouble with lordship with page 44.
Yes.
Let's start with 44. Read petition. 44.
Give me the read. So this writ petition WPC 1702 was instituted
1702.
before the DPC was held.
DPC was held on 4/3/2023. DPC was held and we filed a writ petition, my lord. We challenged that.
Much later.
We didn't knew that day itself, my lord, that day itself. Now, my lord, I'll just point out one thing, my lord. In the prayer portion, we have mentioned, my lord, at page 18, my lord. Kindly see page 18, my lord. Page 18, paragraph 8. Paragraph
No,
8.
Mr. Das, I'm asking this question to understand. The DPC was held on 4th of March 2023. Is that correct?
16th of March.
16th of March.
Yes.
So on that date, there was no question of challenging the minutes of the DPC because you did not know whether your client will be recommended or not.
Yes, right.
Your only grievance was that since his seniority has been brought down, the process of promotion should be stalled.
Yes.
Correct. The learned single judge says it need not be stalled. The state need not be restrained. You proceed with it, but do not finalize it till the or without the leave of the court.
Yes.
Now they have proceeded. They have considered your client, others, and finally they have recommended the 2 candidates. One of them is the applicant. Correct.
Yes.
Yes. Now, your client has not been recommended. Okay. So,
I have nothing to say. My client, because my client is merit with due regard to seniority. 1978, there was a rule, there was amended in 1990. Now it says merit with due regard to seniority. Absolutely, there is no problem. If I doesn't excel so far as merit is concerned, I am out. But here the problem is somewhere else. Here there is an amendment of 1990 rules, that is 1991, where it says the eligibility of the candidate has to be seen. Seniority, with due respect, my lord, seniority and my eligibility are 2 different concepts altogether. 2 different concepts. You have to eligible for that particular post. You are not eligible for that post. This is my case, my lord. Kindly see.
no,
In
I understand.
1990
Mr. Das, the other question I'll ask after that you can continue.
Yes.
If this order is continued, then the post of chief engineer will remain vacant. Your
Yes.
client cannot become chief engineer.
No, they're acting the in charge chief engineer. My lord, there is a rule, my lord. Can we bypass the rule, my lord? If the rule they change, they If the rule is repealed, that's a different thing altogether. As on date, that is a rule.
But is that the subject matter of challenge in the writ petition?
No, we have challenged it, my lord, we have brought it because this we brought it because of the selection which has been made. We thought that eligible candidate will come into zone of consideration. Merit with due regard to seniority, absolutely fine. But that is the eligibility criteria. For the post of additional chief engineer, from superintendent engineer, it should be qualifying service 5 years. That's why I started with page 44, my lord. Kindly see page 40. I'll show an authority in this particular case, my lord, or judgment. Page 40, kindly see 44, my lord. Kindly see page 44.
Yes.
44, this was a DPC which was held. Minutes of meeting, kindly see, my lord.
Yes.
Minutes of meeting of selection board for selection officer promotion from the rank of additional chief engineer under irrigation held on 23/7/2019. Right, my lord? So my learned friend's client at that relevant time on 23/7/2019, my lord, he got superintendent engineer only on September 2019. Your lordship will kindly note down. All that before that, my
It
lord.
says from the rank of additional chief engineer.
Yes.
So
Now,
additional chief engineers were to be promoted.
now for the post of superintendent engineer to additional chief engineer, there is a qualifying service. You have to have 5 years of qualifying service, my lord. 5 years of qualifying service. Then your promotion from superintendent engineer, you are eligible to hold the post of additional chief engineer. Now he is particular appointed as superintendent engineer promoted in September 2019.
And what is the qualifying service?
Qualifying service from kindly see is 5 years. 5 years to hold. You have to hold that. Kindly see next page, my next page. In the principal rule 12, sub-rule shall be subject for promotion from one cadre to another of the service, and officer shall be eligible if he has rendered the minimum continuous service on the 1st January of the year of promotion. Now, if you are 4 superintendent engineer, so these are all qualifying service. 5 years to the post of additional chief engineer. So this is what? My lord, merit with due regard seniority, absolutely fine.
That's right, I got your point.
Now, I'll show one authority of the judgment of the Supreme Court, 2020. But this is passed by the Honorable Chief Justice. This is 2020 11 SCC, page 399. Kindly see paragraph 85, my lord.
Yes.
All judgments has been discussed, my lord. I'll tell your lordship, right from Indraswamy judgment, all judgment has been Nagaraj, Ajit Singh to all decided. What is the concept of catch-up rule, my lord? Kindly see one facts of the case. I'll see one paragraph, my lord. That will kindly see at 409 at paragraph 6, my lord. Then your lordship will be clear.
Yes.
Essentially, the case of the appellant is that in the seniority list of DTTPs, he ranks senior to the first respondent. Now, first respondent is the reserve category. Appellant is a general category. The first respondent was promoted on JDP on 11/8/2011, while the appellant was promoted later on 2/7/2013. The appellant claimed that once he was promoted so and so, the catch-up rule must govern, and in consequence, he must gain seniority over the first respondent. In order to appreciate this aspect of the appellant given, material facts pertaining senior lists are provided. Now, these are facts. Kindly see now at 438 at paragraph 85. This is what the issue of. Seniority and eligibility are distinct concepts in service jurisprudence. Seniority by itself cannot prevail, whereas senior lacks eligibility for promotion to a higher post. Even if the contention of the appellant on the applicability of catch-up rule were to be accepted, that will not obviate the requirement of his fulfilling the condition of eligibility for promotion to the next higher post on the date when the vacancy occurred. So I was showing page 44.
Yes.
Now kindly see page 44. This is what I was pointing out before, lordship, 44.
Yes, please.
This is what the DPC was held, my lord. I was promoted to the post of additional chief engineer. Your lordship will find at page 49, recommended for promotion 49.
What is the name of the applicant?
The name of the applicant is
is my lord,
K.M. Gopal.
K.M. Gopal Sana Rajkumar.
So 48,
When was he promoted to the post rank of additional chief engineer?
additional chief engineer, my lord, to the post.
Additional chief engineer 23, my lord.
Yes, 2023. Super engineer, your lordship will note down in 2019. September 2019. Right. My lord, kindly see, page 14 kindly seen, my lord. Page 14 we have given. Page 14, we have given a chart. Kindly see page 14, my lord. Super engineer 2019.
So there is no requirement of completing particular number of years as additional chief engineer. That is not there. But from superintendent to additional, it should be 5 years.
5 years and from
Has he
additional chief engineer.
completed that 5 years?
No, my lord, that order of my promotion as additional chief engineer is not under challenge. It is nobody's case. The case is, my lord, if your lordship kindly goes to page 18, the prayer portion is very clear, my lord. If your lordship would kindly come to page 18, prayer number C. What is their case, my lord?
No, but you agree that he did
Yes,
not-
yes.
he
But
did
that
not-
is not under challenge. My lord, but for their, my lord, wrong operation of the roster, he would have never become SC, my lord. He would have stagnated as executive engineer. But for the reservation, he is here. It is not under challenge. Kindly see what is the prayer, my lord. Page 18. A writ in the nature of mandamus should not be issued, directing respondent authority to withdraw and forbear from giving effect to the impugned gradation list dated 4/3/23, issued by notification, and restore the seniority of the petitioner above private respondent number 4 to 8 as per rule 22 and 24 of the engineering service by nulli. If, my lord, they are insisting on fixing seniority according to rules, then according to the rules, if promotions are affected, he would have never been in zone of consideration but for the roster. So, my lord, you can't just approve it and reprobate. When it comes to seniority, my lord, you will say apply the rules. But when it comes to promotion, don't apply the rules. Your promotion is roster promotion all throughout.
No, I'm
Now
sorry.
that order, I'm sorry,
No,
order of, my lord, promotion as additional chief engineer is not under challenge. That qualifying service of 5 years and all, that is not a subject matter. Their only case is, pursuant to Article 16(4)(a), they are entitled to both accelerated promotion and consequential seniority. Therefore, they should be given. Assuming that is answered, I still remain in the zone of consideration. I can still be considered for the post of chief engineer, which has been done, my lord. Now, these are the aspects which will go at the time of hearing. A prima facie, my lord, what is there to stall the promotion? And similar order I have already indicated, my lord. He was considered.
But I don't know. That's the water resources I have not. Your lordship considered. Water resources, what the rule says, I am not aware. But so far as the irrigation department is
So
ruling,
your one point is that his promotion to additional chief engineer was not in accordance with rule. That is one point.
superintendent to additional chief engineer also,
Hmm.
he is not qualified to the post of additional chief engineer for a period of 5 years. Now for the promotion to the post of additional chief engineer, we require 2 years qualifying service. Forget about for a moment of a chief engineer, my lord. To hold the post of additional chief engineer, that 5 years qualify, you don't have that.
No, but as he is pointing out, that may be a valid point of
My lord,
argument.
what I am saying.
But is it
My
an
lord,
issue in this
Yes,
report?
I'll tell your lordship. That's from superintendent engineer, it is all on merit, based on merit. It's a fact that I got the benefit of an accelerated promotion. First, once I got the benefit. Now I don't disagree that catch-up rule has gone. Catch-up rule is there, my lord. I'll not argue and say catch-up rule is not there. What I argue in this particular case, please look into the eligibility criteria. I got promotion throughout on merit, my lord, from superintendent engineer, additional chief engineer. Is it not on the base of reserve? I being a reserve category, I didn't get the benefit. Only once I got the benefit, my lord. Only once I got the benefit. thereafter all on merit. What all I am
Okay,
saying.
finally, one question. If
Yeah.
this order remains, your client doesn't become chief engineer.
No, then no, my lord, it's not that. That what about my learned friend's client? Can he get a benefit of what the rule says?
No, that will come later. You are the petitioner. How do you stand to benefit?
Additional chief engineer to chief engineer is 2 years qualifying service. Now, my lord, there was a writ petition which was filed when the DPC was held in 2019. And in the DPC,
Mr. Das, I have followed your argument.
Yeah.
You may have advanced very weighty arguments.
yes,
We will have to consider that. Now, today what I'm asking is, the court has granted the government leave to proceed with the promotion procedure. Your client was also considered. The recommendations excluded your client for whatever reason. If you are aggrieved, it is open for the petitioner to challenge the DPC recommendation. That is all right. But if the interim order is continued, your client does not become the chief engineer in the interregnum. Whatever arrangement is made, whether it is a temporary or permanent or whatever, all will be subject to outcome of this.
but my learned friend will get the benefit of
But
it.
it will be a
How
subject.
come my
to-
learned friend, I am asking myself,
Hmm.
how my learned friend gets a benefit when he is not eligible for that post?
You challenge it.
Yes, he is not eligible. So,
You
my
challenge
lord,
is
the
required.
government is aware of that. They are the rule making authority. They made the rule. 1991.
Mr. Das, you see, I appreciate the anxiety of the respective clients. If you do not challenge that aspect, how are we going to answer that? This is your submission that he is not eligible. But each issue has to be considered and adjudicated in the facts and circumstances of each case. Once you challenge that he was not eligible to be considered for the post of chief engineer, and we get the response from them, that is only when the court can give an
He
answer
is
to that.
not eligible not only for the post of chief engineer. With great respect, I'll submit. He is not eligible for the post of additional chief engineer also.
But then where is the challenge to
Yes.
these?
My-
These are
these
your
are-
submissions.
No, that's a rule, my lord. I am showing the rule. Rule, I can show it, my lord. As a fact, as a matter of fact, I have given a chart to my.
So according to you, there is no need to challenge.
No, my lord, I am not saying, how can I say, my lord, already I am rule, my lord, I can argue on the basis of a rule, it's a law, my lord.
Mr. Das, perhaps you need to, you see, the point is you are saying that set aside his recommendation as chief engineer
Without challenge.
on grounds that he does not fulfill the eligibility norms. But till today, there is no challenge to that. That's what I am pointing out to you again and again and again. If you challenge it, the challenge may or may not succeed. The perspective you are showing is a tentative perspective, which may sustain or may not sustain also. But unless there is a challenge, the question of going into that does not arise. Where is the challenge today to the recommendation of the incumbent on the ground that he was not eligible?
He challenge it.
And
But again, the problem will
otherwise, how
come, he
does the
gets
court?
that benefit and he'll continue, my lord. That's
Yes,
the
he will
problem.
continue. He will
Yes.
continue unless
And
the court
that
passes
rule-
an order.
Their rule doesn't provide and he'll continue. And the government, my lord, with great respect, I am telling the government should have gone to the rules.
Absolutely. But
How they have sought a DPC
yeah,
and
file-
DPC, all they have
file a
decided.
writ petition for seeking a direction to the government to strictly comply with the rule. Where is that writ petition?
No, that's true, my lord. I am saying that's true. I am showing the rule
The
and the
court
DPC.
is not concerned who gets a,
Man,
who
court
gets
is
to
concerned
continue
about
and-
the law which has been what
of
the
course, where is the
statute.
challenge?
Statute. What is
Where
the
is the challenge?
statute?
Where is the challenge?
Government, that's why I'm sorry to say the government, knowing the rules, my lord, and they were so hurried that they made a DPC, they said, and they decided 1, 2, 3, 4, 5. Oh, I know, kindly see, my lord, the government in what manner? And they all negated by virtue of 18-1-2000. You are welcome to brought this notification of 18-1-2023.
If your client gets any benefit due to continuance of this interim order, we will continue it. If he doesn't get any benefit, we'll vacate it.
No, that's true. I will not
That's the
argue.
long and short of the
My
matter.
lord, that I will also not argue, which is, I also know my limitation, my lord. I
If
know my
if you
limitation.
can show that because of this reason, his appointment is bad. So if you continue the stay order, I get the benefit I'm open to consider it.
Then your lordship will.
Otherwise, difficult. It can't be that if I don't get
No,
it, let
that's
him
why I
also not
said,
get
my
it.
lord, I will not argue somewhere, my lord, where catch-up rule is not is applicable. Merit with due regard seniority, well, fine, I accept it. But what about the eligibility criteria? It's true, my lord, it's true that this is not because it was subsequently we came to know about this 1991 rule, the eligibility part.
That's correct.
With 1990, because we were aware that 1990 there is merit with due regard. I have nothing to say merit with, I am out. Merit with due regard seniority, my lord. I'll be happy, I am happy that merit wise.
If he is not eligible, then he will be, even if he gets an interim relief, he'll be stripped of all the salary, etc. Everything will have to be returned.
That's your lordship,
promotion.
that's what my.
But you
case-
have not challenged that.
No, right, that's right, my lord. Lordship will give a direction that we'll be open to challenge that particular. We'll challenge it by,
Yes.
day after tomorrow we'll place.
Yes. It
After
is subject to outcome of the writ petition and
Yes,
any orders passed by the court.
yes.
You challenge it.
Yeah.
Let us see what is their response, and then if you succeed.
We also, we also didn't knew about 1991 amendment.
Hmm.
1990, we were under, believe that 1990 rule, merit with due regard to seniority. My learned friend is right. Merit, you have also in the zone of consideration. But when we found in 1991, there's the eligibility criteria, then that's the reason why we pointed out. And the government knew about this, my lord. They could not have proceeded.
That's correct. I'm
No,
again
right, your
repeating.
lordship is right.
You may be absolutely correct on that. But it becomes a
Yes.
collateral issue in this proceeding. Unless there is a direct issue and they are asked to respond, how do you pass an order on
No,
that?
that's right, my- that's right.
Hmm.
Absolutely, your lordship is right. I am saying that that was what we were not aware of that 1991 amendment rule.
All right, Mr. Majumdar, what do you have to say?
Very simple, very. If you go by the eligibility criteria,
Hmm.
if interviews are also not right. How can I file a writ-
But that is why if he challenges, you respond, then only
He
we'll
got
see.
the promotion on 7/1/2023, madam. Even he has not started 2 years.
And who is responsible, my lord? In 2014, he filed a writ petition where he stalled the promotion of general category candidates.
That's
And
why-
that is still pending.
No, my
We have
lord.
annexed that stay order.
No, 2019 when DPC was held, general candidate came forward
My lord, they-
and filed a writ petition, and there was an interim order passed by the court. And only on interim order, they retired, already general candidate retired, and thereafter this interim order was vacated. Not because of mine, my lord.
Yes, take down. Heard Mr. K. N. Chaudhary, Learned Senior Counsel, assisted by Mr. S. K. Goswami, Learned Counsel appearing for the applicant. Also heard Mr. D. Das, Learned Senior Counsel, assisted by Mr. D. M. Mahanta, Learned Counsel for the writ petitioner stroke opposite party. Mr. Dilip Majumdar, Learned Additional AG.
Sir,
Assam.
lordship's kind permission, can I take?
Yes, yes, assisted by Mr. N. Upadhyay, Learned Standing Counsel, Irrigation Department, Assam, is present on behalf of the official respondents. Full stop. The controversy involved in this proceeding pertains to filling up of 2 vacant posts of chief engineers in the irrigation department of Assam, of the state of Assam. Full stop. The applicant was one of the candidates who came within the zone of the applicant, namely. What is the name of the applicant?
KM Gopal Sanaragat Kumar.
Then why is it written applicant Dhiraj Saikia?
Hirat Sokya was the original petitioner, petitioner.
Uh, No, in the name of applicant also Dhiraj Saikia has been written. Who is there for this? Who is there for the applicant? Yes.
He is Hirat Sokya.
Where is your application?
Lordship will find page 3.
Yes.
Page 3, I have
Yes.
given Lordship KM Gopal Sanaragat.
Yes.
In the writ petition, we have stated this is the writ petition.
In the application, what is the name of the applicant? Which page? I want to see that.
Page 3, Lordship.
Yes. Yes, page 3. Where is the name of the applicant?
KM Gopal Sanaragat Kumar. Last portion,
You are talking about IA number 882 of 2023.
Lordship.
Please give it to me. Please flag where the name of Gopal Sana has been written. Is this the IA or there is another IA?
No, 923.
Give me that IA. This is the idea. Okay. All right, all right. Hmm.
I'm not, with your lordship's permission, one matter is bottom of.
Yes, 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 yes. Hmm. The applicant. K.M. Gopal Sana Rajkumar was one of the candidates in the rank of additional chief engineer and was in the zone of consideration. First of his case, along with the case of the writ petitioner and other eligible candidates were considered, whereupon the applicant was recommended for promotion to the post of chief engineer. However, due to the operation of the interim order dated (29/3/2023), passed in WPC number 1702/2023, where the state has been granted leave to proceed with the process of filling up of the two vacancies of the vacancies in the post of chief engineer, but not to finalize the same without the leave of this court. No order of promotion, no formal notification filling up the vacant post of additional chief engineer has been issued till today. First of, hence, this IA has been filed with a prayer to modify vacate the interim order dated 29/3/2023. First up. Mr. Chaudhary, Lani Senior Counsel for the applicant, submits that the case of the writ petitioner stroke OP number 8 has also been considered by the DPC along with other eligible candidates, whereafter the name of the applicant has been recommended. Therefore, he cannot have any grievance in the matter, more so when the minutes of the DPC is not under challenge. First up. Mr. D. Das, Lanet Senior Counsel for the OP number 8 stroke writ petitioner, on the other hand, submits that the applicant did not complete 5 years of continuous service in the rank of superintendent engineer and therefore was not even eligible to be promoted to the post of additional chief engineer and thereafter to the post of chief engineer in the department. Full stop. In support of his above argument, Mr. Das has relied to the and has referred to the rules of 1990. Is it rules of 1991? To the Assam Engineering Irrigation Close Department Service Rules 1978 as amended on 13th of June 1991. Full stop. However, what remains to be seen is that there is no challenge to the eligibility to the candidature of the applicant on the ground of non-fulfillment of his eligibility. Full stop. Mr. Majumdar, D. Majumdar, learned additional AG Assam, submits that the same criteria would be applicable to the OP number 8 stroke writ petitioner as well, as he has also not fulfilled 5 years of service in the rank of superintendent engineer. Be that as it may, since the issue pertaining to eligibility of the candidates is not eligibility of the candidates for promotion to the post of chief engineer is not the subject matter of this proceeding. Hence, this court need not be detained on the said aspect of the matter. First up, what is to be noted here in that the post of chief engineer in a department or in a technical department is of immense importance. And if the said post is kept vacant, then it is the public who suffers ultimately. Therefore, I am of the view that, now, moreover, if the interim order is continued, then the applicant, then the OP number 8 stroke writ petitioner that does not stand to gain anything in as much as until such time the writ petition is decided, the scope does not stand to gain anything in as much as until such time the recommendation of the DPC is finally set aside. No mandamus can be issued in favor of the applicant. Considering the above, the department is granted leave to go ahead and issue and notify the promotion of the selected candidates to the post of chief engineer in the Department of Irrigation. Stop. The interim order dated so and so stands modified to the above extent. It is, however, made clear that promotion orders issued in terms of the leave granted by this court would be subject to outcome of the writ petition. IA stands disposed of accordingly. What is the other IA? There is another IA. What is, you have filed an IA?
Today, affidavit of opposition has been filed.
All right, next matter.
Well, this matter is relating to the promotion to the post of senior assistant mallard. The draft gradation list prepared in 2018 mallard, where my name appears as serial number 18 mallard, and the juniors have been promoted. Impugn order has been passed. That is why this petition has been filed, mallard. So now, mallard, they have filed the reply and affidavit. Only contention of their affidavit is, my lord, because of my SCR, my lord, I have not been promoted. And other writ petition also filed from the same respondent office, my lord. During pendency, they have been promoted, my lord.
Yes.
Lordship, in my affidavit, Lordship, it appears that Lordship, the annual SCR are recorded by the higher authorities such that the petitioner is not fit for advancement of the next higher post, Lordship. Means it is not.
Where is the SCR? Where is the SCR grading?
In paragraph 7 in my affidavit, it is.
Has it been communicated to him?
Lordship, that point is silent here in this affidavit. Lordship. Regarding the communication part, Lordship, it is silent in my affidavit, Lordship. I have to take a single instruction on that record. So if not communicated, he will get the advantage, Lordship.
Well, to my information, there was no such HCR made in that during period, man.
You produce the
Yes,
relevant record.
Lordship.
Yes, heard Mr. So-and-so, counsel for the applicant. The petitioner is a petitioner. The writ petitioner is aggrieved by the impugned decision of the authorities to supersede him while promoting respondent numbers 6 and 7 to the post of
Senior assistant, Lordship.
senior assistant in the establishment of Deputy Commissioner Hailakandi. Full stop. It appears from the affidavit filed by the respondent number 2 that there was adverse remark in the SCR of the petitioner, as a result of which he was denied promotion. However, the learned government advocate could not indicate as to whether such adverse entry in the SCR was ever communicated to the petitioner. Moreover, the records are also not available to ascertain as to what was the nature of adverse communication. In view of the above, on the request of Mr. Goswami, this matter is directed to be listed again on 29th of May 2023 as a fixed item so as to enable him to produce the records along with necessary instructions on the above aspect.
Item 17 and 18.
Meet your lordship. Lordship, I am appearing on behalf of my senior, Mr. D. Nath, my lord. He has instructed me, he is going to file affidavit during the course of the day, my lord, from the government side.
By order dated 10th of February, they were directed to file a detailed affidavit. Providing the details of.
Call him. Let him
Lordship,
come. What
My-
is there in the affidavit? Let us
my lord.
pass over for the time being.
Item 19.
Lordship, kindly fix the matter after Bihu, Lordship. In the meantime, I will submit the affidavit, Lordship.
That may be fixed.
Yes, heard Mr. B. Kumar, learned counsel for the petitioner, also heard Mr. J. K. Goswami, learned additional senior government advocate Assam appearing for the state, who prays for and is granted further 3 weeks' time to file affidavit. Let this matter be listed again on 17th of May 2020.
21.
It is Lordship. Lordship, this is a matter relating to compassionate appointment. Lordship.
Hmm.
But the father of the petitioner was working as the assistant engineer in the public health engineering department, Sonai division, my lord. He died on 13/11/2014. Thereafter, the petitioner made her application on 20/12/2014 notes. Then the DLC recommended, the recommendation of the DLC, my lord, will find at page 32, my lord.
Hmm.
If my lord takes up page 32. Serial number 1 is the petitioner, my lord, Silpika Bhuya. My lords, from the DLC my notes, what it comes out is that there was no vacancy in that particular office of the PHE, Sonai division. So DLC recommended that the case of the petitioner may be considered against any other vacancy within the state. My lord, thereafter, the SLC communicated to me on 17/2/2018, saying that my case could not be considered due to want of vacancy. Then thereafter, again, the DLC recommended my name. There was a vacancy that had that had arisen. So SLC recommended my name. This time, the authorities said that since the 2 years had elapsed from submission of the application, my case could not be considered. After that, I made certain RTI applications, and I came to find out that there were in fact vacancies available within the department itself in other districts during that particular period of time. And my case still was not considered. And in fact, if my lord takes up the DLC minutes,
There is a direction to consider your case.
there was a direction from the DLC, but SLC,
They said that no vacancies were available.
yes.
But you saw that the vacancies were
Yes.
available.
I had filed an affidavit.
File contempt. We are not going to adjudicate this matter again. File contempt petition, will issue notice and haul them up. Why should they go on doing the same exercise
There
again?
was the direction from the DLC, not from this court. my lord. So
Lordship, DLC is recommended.
there's DLC
Submission-
recommended.
There is no honorable court order regarding.
There is no
this
court
matter.
order as such. So
Lordship may kindly have a look, page 28,
Page 28.
my lord. This is the communication from the Andhra Secretary to the Chief Engineer PHC, my lord.
this is the second time when the case of the petitioner was put up.
So what is your submission?
Lordship, my submission is that the case of the petitioner was considered as per notification of 2009, my lord, because her father was there in the year 2014. At that time, 2009 notification was prevailed. There is no provision that some other department may be considered if there is no vacancy. Regarding the vacancy position, my lord, the PH may file an affidavit if there is any vacancy at that point of time or not. I'm appearing for the SLC or DLC, my lord. PHC, my friend, may kindly take instruction from the department.
Take inspection from the department whether we'll file affidavit, lordship.
You have filed.
No, we will file affidavit.
I have filed an additional affidavit showing that there were in fact vacancies.
Then what is, if you're accepting that, then we'll issue.
Lordship will re-verify. Lordship will re-verify it. Lordship, they have filed from the RTI. Lordship will just check and come back. Lordship.
Mr. S. Vishwakarma, learned counsel appearing for the petitioner submits that on the basis of RTI replies received by his client, it transpires that there were vacancies at the relevant point of time to accommodate the petitioner on compassionate ground as per the recommendation of the DLC. So notwithstanding the same, the SLC has not considered the case of the petitioner, full stop. Hence this writ petition, full stop. Mr. S.M. Hassan, learned standing counsel PHE, Department Assam prays for his grant and is granted 3 weeks time to verify facts and file appropriate affidavit responding to the allegations made by the writ petitioner. Let this matter be listed again after 4 weeks.
My lord, the petitioner here was serving as a nurse, and on her transfer, she was not told at that point of time the place of posting. She was simply relieved. Coming to know the head office to where she should report, she went and reported. They did not give her a posting. She came back to Guwahati, and unfortunately, she suffered schizophrenia, my lord. And she could not report back for duties. The department also did not call her for duties. That was in 2018. Now in the year 2019, my lord, the prayer before this honorable court is, since she has not been terminated, she joined in the year 1992. My lord, if they can consider her voluntary retirement or compulsory retirement, whatever, my lord, so that she at that point of time when she did not report, my lord, she had a service of around 17 years at hand. If it is taken to be continued till now, it is, my lord, more than 34 years. So they had to take a decision whether I can be allowed to go on voluntary retirement because I cannot serve in this mental condition. Documents are there. That is the very prayer in the repetition. Their affidavit in opposition simply says that she did not report, and they have annexed a document which was supposed to be my document, the copy that was supposed to be given to me, the transfer. They have produced it in the affidavit in opposition, ticked in my name. If the copy of the letter contains a tick on my name, it should be with me. But they have produced it before this honorable court. So it is almost admitted that I was not told where to join. And I could not.
So why don't you file a representation? They let them
File a
consider.
representations are filed since no response was there.
2020,
We-
a husband filed a representation.
Yes, on behalf of the wife, because she was not keeping well at that point of time. Thereafter, the wife also filed, my lord.
She was serving as a nurse.
Nurse, my lord.
But
in the
classed as
FMCH.
a pharmacist.
I'm sorry, my lord. She's a pharmacist.
No,
my lord.
pharmacist.
It's pharmacist, my
Pharmacist.
mistake.
And release order was there, Lordship.
And
Release
where is
order
the
does-
transfer order?
Yes, Lordship.
Transfer order?
My lord, lordship will have page 15 of the writ petition. That was the relief order.
Transfer order.
Answer. One minute. That was a relief order, my lord. Does not say where I have to join.
Page 15, annex of 4.
Annexure 4. That was the relief order given to me.
Transfer order.
This is the release order, page 15.
And
Where is the transfer
their
order?
affidavit in opposition, my lord, page 10, annexure 2 is the transfer order.
Yes.
Type copy is also there. But in this original order, lordship will find down below, ticked to my name. And they produce it. If it is ticked to my name, it should have been with me. This is my copy, but it is with their affidavit in opposition. Therefore, this was never given to me. I did not know what to do with it.
You submit a representation. On our behalf, let a representation, fresh representation be submitted and let it be considered and decided.
Take a time frame, my lord, she's suffering.
Yes.
Either it's a pension or it's whatever decision.
Yes.
Within 90 days. All right, take down. Heard Mr. R. Majumdar, learned counsel appearing for the petitioner, also heard Ms. S. Sharma, learned standing
All
counsel,
the respondents.
health department appearing for all the respondents, full stop. The writ petitioner hearing is an employee under the Health Department of the Government of Assam. While serving as a pharmacist in the MMC hospital. No, to write like this. She was appointed as a pharmacist by appointment order dated 6/2/1992 and posted at the MMC hospital.
No, this transfer by appointment. Order, what is it?
No, page 12 is the appointment order.
Page 12 is 4th of February, my lord.
Yes,
That
that
was
is
the
the appointment order.
Yes.
She was by order dated 4/2/1992, the petitioner was appointed as a pharmacist in the Mahendra Mohan Chaudhary Hospital, Guwahati, and posted in the OPD section of the hospital. While serving as above, the petitioner was apparently transferred from the MMC hospital and posted at,
The disposal of the Joint Director of Health Services, my lord.
Yes, sir.
and her services were placed at the disposal of the Joint Director of Health Services, Kachar, Silchar, for posting her against existing vacant post of pharmacist. However, according, next, it appears that on 11/7/2008, okay, order of transfer is 23/6/2008. It appears that on 11/7/2008, the petitioner was released from the MMC hospital so as to enable her to join the new place of posting. According to Mr. Majumdar, the transfer order dated 23/6/2088 was never served upon her client, on his client, as a result of which she was not aware as to the place of, new place of posting. While the petitioner,
Lord, may I interfere?
Yes,
Lordship,
yes.
I'm very sorry. Lordship, page 9, the copy forwarded to person concerned Srimati Jamuna Rani Goswami.
That is what I was showing. The tick mark paper is with them.
that will write when your submission is recorded. Now I'm just recording his submission.
Oh, Lordship.
He says he has not received. Am I not entitled to put that in record? I
Lordship.
will write. What have you written? First up. While waiting for clear instruction in this regard, the petitioner suffered from schizophrenia, a mental disease, as a result of which she was rendered unfit, as a result of which she was unable to continue to discharge her services. First up, till today, the petitioner is in a precarious health condition. First up, Ms. Sharma, on the other hand, submits that a copy of the transfer order was marked to the petitioner. Therefore, it cannot be said that she was not aware of the place of posting. First up, I find from the materials available on record that the petitioner had never joined at Kachar in terms of the order dated 23/6/2008. First up, whether or not she was served with a copy of the transfer order is a disputed question of fact which cannot be adjudicated in the writ petition. First up, however, the fact remains that many years have passed since the petitioner was transferred, and there is no material on record to show that the authorities had ever initiated any disciplinary proceeding against the petitioner. First up, her services have also not been terminated. First up, Mr. Majumdar submits that all that his client is seeking is consideration of her request for voluntary retirement or even compulsory retirement so that she can somehow survive the rest of her life with some pensionary support from the government. Full stop. The prayer made by Mr. Majumdar will have to be considered by the departmental authorities at the first instance. Therefore, without expressing any opinion on the merit of the claim of the petitioner, and as agreed to by learned counsel for both the parties, this writ petition is being disposed of by providing that within 2 weeks from today, the petitioner may submit a fresh representation before the Commissioner?
Before the Director of Health Services.
Director of Health Services, making her request as as noted above. If such a representation is submitted by enclosing a copy of this order, the same be considered in accordance with law and disposed of with a reasoned order as expeditiously as possible, but not later than 90 days thereafter. With the above observation, this petition stands disposed of.
Obliged, my lord.
Ma'am, sir, this matter relating to my promotion of junior engineer to the post of assistant engineer. The petitioner has been serving as junior engineer since 1997. And initially, my lord, he was appointed as section assistant. Thereafter, he was promoted to the post of
Serving as junior engineer since
1997. But he was appointed at initially sub-engineer grade 2 in the year 1994. And thereafter in the year 1995, the petitioner was promoted to the post of sub-engineer grade 1. And thereafter, my lord, he was promoted to the post of senior engineer in 1997.
And before my learned senior starts, Lordship, here an amended writ petition has been filed. We are required to file an affidavit in response to that, my lord. We took some time, my lord. Lordship may give us 2 weeks further time, my lord.
Last occasions also in several times was given, my lord. I think, my lord, affidavit is earlier they filed the affidavit. Only the, my lord's last.
What really is the issue here? What is the issue?
Issue is that, my lord, my past service as grade sub-engineer grade 2 and 1. It is equivalent to junior engineer, my lord. Qualification is same. That was not counted. If that would have been counted, my position would be much higher in the graduation list, my lord. That is my prayer, my lord. I filed so many representations and that is pending about the department. That was the.
No, are you seeking any promotion?
Yes, my lord. Promotion.
Promotion to which post?
Assistant engineer.
Assistant engineer.
Engineer civil PWD. And accordingly, graduation list has been prepared, Lordship, my page 27, wherein my position has been shown as 155. Page 29.
Page 20?
29. And my position, serial number 155. Bakul Roy. And one Kumud Patok, serial number 141 has been placed, who is junior to me. And that is under challenge, my lord. This. And also my another prayer is that, my lord, if my past service has.
Just a minute. You are claiming seniority above whom?
Seniority above, my lord, Sri Kumud Patak. 141, he was placed.
But is he a party in the writ petition?
No, he's not a party.
He is not party.
Then it cannot be considered. Why are you making these mistakes, Mr. Nath? If you want seniority above a person, is he not required to be made a party?
And my main prayer is that, my lord.
Yes or no? First answer the question.
No, my lord. My main prayer is that, my lord. I'm not.
If you are seeking seniority over a person, he is not required to be made a party.
He is required to be party.
Then why have you not made him a party?
So I may well have to implead him.
These matters are unnecessarily getting stuck up for needless reasons. You are claiming seniority over someone, you don't make him a party. These orders even if passed, will be set aside in the appellate court.
That's right.
On the prayer of Mr. S. Nath, learned counsel for the petitioner. This writ petition stands adjourned for 2 weeks so as to enable him to implead the departmental candidate over whom the petitioner is seeking seniority. In the meantime, the department may also file affidavit responding to the allegations made in the amended writ petition. On the request of Mr. Nath and Mr. S. Nath and Mr. D. Nath, learned counsel representing both the sides, this writ petition is directed to be listed again as a fixed item on 15th of May 2023. Don't make these mistakes, Mr. Nath. You are causing unnecessary injury to your client.
This is regarding promotion, my lord. Can it be taken immediately after the vacation, my lord?
Yes.
On 26th, lordship.
All right. On the prayer of Mr. B. Chatri, learned counsel for the petitioner, made with the consent of the other side, this matter stands adjourned and shall now be listed again on 26th of April 2024. 2023.
Well, here the question is one of prolonged suspension of the petitioner. And the petitioner was suspended on the basis of a conviction by a court of criminal law, my lord. And thereafter on appeal, the conviction and the sentence both have been stayed by the Honorable Appellate Court, my lord. However, the respondents will continue to keep me under suspension from the year 2020 onwards. On the basis of the Supreme Court law, my lord, which says that prolonged suspension in such matters would not be necessary when my offense was not one which connected with the department or which could have harmed the department at all. The conviction was on the basis of an attempted murder, my lord, after a land dispute. I was suspended because I was convicted. Conviction and sentence now state for 2 years, last 3 years, my lord, I am under suspension. All my promotional avenues, others have been allowed to undergo the promotional courses. I have been, my lord, kept under suspension without any increase in the subsistence allowance also.
Where is the order staying your conviction?
My lord, yes. That lordship would find at page 58 of the writ petition. I'm sorry, my lord. That lordship would find at page. Yes, my lord, page 29. Page 29 of the writ petition. They had initiated a proceeding under Rule 19 of the CCS rules also to terminate my services on the basis of conviction. That also they have kept in abeyance.
Sorry, what did you say?
They had initiated a process to terminate my services under Rule 19 of the CCS rules, which permits a termination on the basis of a conviction. Now that has been kept in abeyance by the department. But even after the stay of the conviction, my lord, my suspension continues from 2020. They keep it.
So any authority in your favor?
My lord, yes, the judgment of this the Supreme Court, my lord, which was 2018, OPDA 9, 2017 SCC 677, my lord, para 27, referring to Ajoy Chaudhary, it is said, this court in Ajoy Chaudhary has frowned upon the practice of protracted suspension and held that suspension must necessarily be for a short duration. On the basis of material record, we are convinced that no useful purpose could be served by continuing the first respondent under suspension any longer, and that his reinstatement would not be a threat to fair trial. The trial period now being over, my lord, I am only in appeal. We reiterate the observation of the High Court that the appellant state has the liberty to appoint the first petitioner in a non-sensitive post. I am there inside the camp, my lord, and sitting there day by day. 50% of the salary as substance allowance given to me. My prayers for increase in substance allowance has also been rejected.
Give me the, yes, whatever you got to say.
Lordship, his conviction is that, but he is not absolved from the charge, Lordship. He is
Then you
convicted.
pass an order, review his order of suspension. You can't.
It is reviewed in time to time, Lordship, and it is founded and only not only on the ground of conviction. In the so cause notice, it is clearly stated that conviction plus, Lordship, his conduct, Lordship, at page. It is at page 53, Lordship, of my
No, the review order, outcome of the review, is it informed to the petitioner?
Yes, yes,
Yes, Lord.
yes.
You have been told.
informing me
Yes,
time to
Lord.
time that this is the
In
cause
time
of
to
review.
time, he is.
I have been submitting my representation saying that it has got nothing to do with my job. My conviction is state, say, they simply say in their orders, if Lordship will find, they simply take the ground that the conviction is state, not set aside.
Not satisfied.
Therefore, continue.
Appeal is still pending.
Now, have they given any reason to say that your conviction is embarrassing us? Your conviction is on a ground which will cause a harm to the department? Nothing of the sort. Conviction is state and not set aside. Therefore, continue. That is the only ground.
He is convicted under section 307 for attempt to murder. And as per the so cause notice, Lordship, his suspension is disciplinary authority has taken into account the entire conduct of Sri Kunal Kishore, Deputy Commandant, which led to his conviction, the gravity of the misconduct committed by him, the impact of such misconduct, which is likely on the administration and other extenuating circumstances or redeeming features. Therefore, only on the basis of conviction, not only on the basis of his suspension is should continue. There is other factor also Lordship considered, which led to his conviction.
Where is it? Show me.
At in our affidavit, page 53, Lordship.
Have you filed rejoinder?
Yes, madam.
Yes,
This matter will then have to be heard finally. We'll post it after vacation. In the month of May. I heard Mr. R. Majumdar, learned counsel for the petitioner, also heard Ms. R. Devi, learned CGC, appearing for the respondents. It is submitted at the bar that pleadings are complete in this case, and therefore this matter can be taken up for final disposal. Considering the nature of grievance expressed in the writ petition, this court is of the opinion that the writ petition would call for expeditious disposal. As such, registered to list the matter as a fixed item on 23/5/2023 for hearing.
I'm obliged.
Portal and over admit the writ petition. Registered to list the matter.
My lord, may I kindly have item number 28, my lord. WBC 597 of 22. My lord, there was an advertisement. Pursuant to the advertisement, these 4 petitioners were, 3 of them were appointed as, my lord, accredited engineer, and 1 of them was appointed as a computer analyst. In the, my lord, department key? Panchayat and Rural Development Department, my lord. Now, my lord, there was an inquiry made regarding some estimates prepared by them for some work. Now, at different stages, my lord, those estimates were prepared. Apparently, my lord, behind the back of the petitioner, there was an inquiry. Pursuant to the inquiry report, my lord, our services has been terminated. There was no inquiry, no notice, nothing. In fact, on last occasion, my lord, Lordships has indicated that more or less on a similar issue, Lordships has dealt with a matter, my lord. And that judgment we have found out. That is, I think that's the case of a constable in the CRPF, my lord. WPC 2277 of 2010. Now, my lord, I'm relying on 2 other judgments, my lord. The first judgment is Lordship recalls a very famous case, that Government Press versus Deliapa. That's 1979, my lord. That is where Supreme Court said, my lord, even if a temporary government employee is also entitled to a notice. And secondly, my lord, Lordship knows in Radhesham Gupta's case, Honorable Supreme Court said, my lord, if misconduct or anything wrong is taken note of, then my lord, Article 311 comes in. In which case, my lord, if not 300, Article 311 it's true sense, but at least, my lord, some hearing is required. It can be that, my lord, there are some allegations which are taken note of. I am not even put to notice. So, and my lord, in this case, I think I have given the, my lord, citation, 1999 to SCC 21. It would be
So let us see in WPC number 597. What is the order of appointment?
Yes,
Where is
order of appointment, my lord, page 29. Page 29, my lord. Kindly, page 29, my lord. Office of the Commissioner of Panchayat and Rural Development, office order dated 2/11/18. Following candidates have qualified for the post of accredited engineer on contractual basis under MNREGA as per written examination held for the same. Serial number 318, my lord. Abdul Karim.
No, but where is the appointment order?
This is the order, man.
What is
Joining
the-
letter is there. Then my lord will kindly come to then contract agreement. Then my lord, page 31. Letter of joining. They have issued, my lord. Dear candidate, in the interest of public service, as newly selected accredited engineer, would like to inform you that after successful completion of induction training program, you have been allotted posted as follows. Accredited engineer, Nalbari, Borkhetri.
These are what, sanctioned posts or under a scheme?
My lord, that's the irony, my lord. What has happened, my lord? The money comes from the, my lord, consolidated fund of the state. When it comes to making payment, whether it is regular scale, whether it is, my lord, with DA and all, and whether it is in contractual payment. Money comes from the consolidated fund of the state. The difficulty is, my lord, we have no choice. Whatever form of appointment is given to us, we have to grab it. Otherwise, we can't survive. And this is what is happening, my lord. In the name of welfare state, this is happening. My lord, this advertisement is there. Come to page 27. The public advertisement. Okay, page 26, my lord. Applications are invited from eligible Indian citizen in prescribed form published in the official website for filling up following position on contractual basis under MNREGA and Pradhan Mantri Awas Yojana under the Department of Panchayat. Accredited engineer 1850. Computer assistant 60.
Now, what has happened? Is there any order terminating your service?
Yes, my
Where is
lord.
it?
Page 39. Whereas an inquiry was ordered by the order dated so and so in connection with alleged misappropriation of fund under MNREGA in Borkhetri Development Block, and subsequently inquiry team conducted detailed inquiry including field visit. And whereas as per findings of the inquiry, the Department of Panchayat and Rural Development, Government of Assam, while later dated so and so has requested for either termination of the contract or severe punishment of so and so. And whereas conduct of the concerned official in discharge of their duties not in public interest and in gross violation of law laid down in so and so. Now, therefore, in view of the above employment contract agreement executed with the employee are hereby terminated and said employer hereby discharged. 1 month additional remuneration in lieu of notice period shall be released. Supposing, my lord, I want to file an appeal against this. What do I say in the appeal, my lord?
Mr. Nath, where is the record to show that inquiry was held? What inquiry was held?
Only the report, my lord.
No, page, we have an next, my lord. Page 42. Page 41. So, page 41, my lord, it starts. And as far as the petitioner is concerned, my lord, kindly come to page number 49. 49. Kindly see, my lord, last towards the bottom at page 49. Abdul Karim, accredited engineer, Borkhetri Development, Bok Nalbari, is responsible for purposefully including unnecessary item and unrealistic provision, such as extra lead ranging from 7 to 9 in artwork with headwork, lump sum items, conveyance amounting to so-and-so, unnecessary unrelated item, namely Jati bamboo and compound zero so-and-so in construction of Agri-Ban Come Road. Another item like worksite facilities, crates, drinking water, first aid amounting to 50,000, which cannot be booked under the work head, and unnecessary duplicate item of extra, a lift of 1.5 so amounting to rupees 3 lakhs and so, whereas there is already a lift of 1.5 included in the main item of artworking. Actually, basically, we prepared some estimates. You don't approve it. What is the question of penalizing us, my lord? All the ministers will have to sack every day, my lord, if they have to follow this. Their commission every day taking. Who judges their conduct, my lord? Kindly see, my lord. I have prepared an estimate. All right, you don't approve it. There are channels. I am the lowest in the hierarchy, my lord. Above me, there is engineers, executive engineer, superintending engineer, directorate. And kindly come to
what
page
is what is the relief you are seeking now?
My lord, this order has to go. This order is in statement, my lord. Let them hold an inquiry. Because they have taken note of misconduct. That means it is founded on some allegation. And you can't without even a notice. My employment will go away. Please come to page 47, my lord. Whose responsibility it is? Page 47, my lord. At the first subpara. It may be assumed that the estimates were purposefully prepared with unnecessary items and unrealistic provision. These items were purposefully forwarded to technical sanction by the executive engineer, who is responsible for forwarding a correct estimate for according technical sanction, objectively considering productivity, quality, and durability aspect of the scheme as per guidelines, rules, circular under MNREGA for onward submission to higher authorities. Now, assuming, my lord, we have included something unnecessary items, it was the responsibility of the executive engineer at his level to screen it, scrutinize it.
And what has happened to the posts which they were holding? Have those been filled up by someone?
It's still vacant according to us, fine.
I have no information as far as that is concerned right now.
No, without that information, there cannot
No,
be
my
an
lord,
order.
no, correct, my lord, but those posts are still vacant. They have not made any, my lord, subsequent recruitment to fill up those posts.
They were not
I am
heard.
against the decision-making process, my lord. What I am
Yes, sir.
challenging is the decision-making process. Can somebody?
No, that I follow, but even if you succeed, unless there is concrete
Yes.
material, reinstatement will not be ordered. That either you have to file an affidavit or we have to ask them to.
Or that instruction lordships can take, my lord.
Mr. Devnath, yes.
Yes, my lord. Instruction.
Instruction to what is it?
I'll do that.
You see, these are all stigmatic in a
Yes,
way.
ma'am.
You have to hear them. This is what rule of law is all about.
Daily commission basis.
Is it not? You heard a lecture 2 days back.
Yes,
That applies to everybody. Or you think your department is above it?
No.
Then please answer, how can you throw out people like this? You have allegations against them and you don't even give them a chance to reply.
I'll take the instruction.
What, you'll take instruction on what?
মানে post kita khali ase na ami kori asili.
Take instruction on how soon they can be reinstated. Heard Mr. K. N. Chaudhary, Learned Senior Counsel appearing for the writ petitioner, also heard Mr. Devnath, Learned Standing Counsel PNRD Assam, who seeks posting of this matter again on 8th of May 2023, so as to enable him to obtain instruction and appraise this court as to whether any show cause notice was served upon the writ petitioners before terminating their services, and also as to whether the posts earlier held by them have already been filled up or not. Full stop. the Mr. Devnath to obtain written instruction and place the same on record on the next date fixed. This case is again on 8th of May 2023 as fixed.
My
item.
lord, in paragraph 30, we have made a statement that those are still lying vacant. They filed affidavit. They have not denied them.
Alright.
Even then, let him have it. Also, kindly give a date.
8th of May.
Why?
July.
Leave it.
Your lordship. My lord, the petitioner was selected by the Gaon Sabha as the secretary of Durgamari VDP party. By 208
Yes,
adult members, and there were 8 persons against me. Then committee was formed, my lord. It was duly formed. It was duly signed by everybody who were present. But at the instance of MLA, my lord, I was ousted. Then I filed the writ petition. SP says that my term is over, though I have discharged my duty with utmost satisfaction. In their affidavit, SP says he discharged, which means I have discharged my duties to the satisfaction or utmost satisfaction. Now, village people selected me, everything was done, but they has appointed private respondent as the secretary. Then lordship.
Mr. J.K. Goswami is appearing on the case. So he is in another court. That's why.
Who is in this court?
Mr. J.K. Goswami, government advocate,
No, he
senior.
is doing 2 courts.
No, actually he is on lakes. He asked me to call him, but I called him already, but he is not. So kindly pass over to matter for time being. Oblige.
May I please, my lord?
May it please your-
By the order dated 8/2/2003, I am supposed to bring instruction whether a particular ACR for the year 2018 and 19 has been communicated to the petitioner or not. And I have brought the instruction, my lord. Perhaps that is already on record. If it is not there, my lord, I have another copy. I can provide it. My lord, instruction has come, but that particular ACR has not been communicated to the petitioner. That is for certain, my lord. My lord, may kindly come to second page. Para 2, it is intimated that ACR of the petitioner for the year 2018-19 has not been communicated to him by his report of a reporting officer or unit, and this fact has been clearly reflected at para 25 of our affidavit in opposition. Now, my lord,
Yes.
now, my lord, by this particular writ petition, the petitioner has sought 3 remedies. First is that the petitioner is entitled to get promoted from the date on which his subordinate officer has been promoted, and petitioner is also entitled to get all MSCP benefit, modified assured career progression schemes benefit, and third, uncommunicated ACRs should not be taken into consideration. Now, my lord, my humble submission is that even if we assume for a moment, since that particular ACR has not been communicated to the petitioner, and so that particular ACR must be excluded from any kind of consideration, even then, the petitioner is entitled to either of these 2 relief, not the both. Either the petitioner is entitled to promotion or the petitioner is entitled to MSCP benefit. For that, my lord, I think the record may be required. So on next day, my lord, immediately after Bihu, I shall bring the record and my lord may dispose of this matter finally.
Kindly see last order, my lord. It is written, my lord.
Where is the judgment? The judgment which helps you.
My lord, I have that judgment.
What is the name of the party?
My lord, Devdatta versus Union of India.
Which is the relevant paragraph?
Paragraph
Have you seen that judgment?
My lord,
Have you seen that judgment?
my lord, I have not seen this judgment. I have not gone.
13, paragraph number 13, my lord.
All right, now there is admission that the adverse remarks in the SCR for the year 2018 and 19 have not been communicated.
Have not been. There.
Therefore, you'll have to ignore that and without the SCR, whatever benefit our client is entitled to, you have to give it.
My lord, for that, my lord, let me go through this judgment. And let me also obtain the instruction from my department concerned.
What instruction?
My lord, whether.
Judgment, whether it is a good judgment or.
No,
bad
no, my
judgment.
lord, not that certainly. But whether this petitioner is entitled for promotion or for the MSCP benefit, if there is sufficient promotional avenues that is available to the department, then he might be the petitioner might get promoted to that particular post. But if it is not available, then the petitioner
Then
is
you have
entitled
to
to.
give him promotion with effect from that date.
Yes, my lord, that is.
Both he will not be entitled to.
Both.
SCP is in lieu of promotion.
Yes,
So
my
if you
lord.
give the promotion with retrospective effect,
Yes, my lord.
with pecuniary benefit, then he will not be, then there will be no requirement to SCP.
Yes, my lord, for that, let me
Why don't
obtain the
you do it?
instruction. My lord,
Why don't you do it? We'll close the matter.
My lord,
Huh?
maybe
my
this
lord,
was
the matter may be immediately fixed after Bihu, my lord. Immediately after Bihu.
Heard Mrs. Bora Learned Counsel for the petitioner, also heard Mr. B.D. Deka Learned CGC appearing for the state, who submits on instruction obtained as per the order dated 8/2/2023 passed by this court, that the adverse remarks in the SCR of the petitioner for the years 2018-19 have not been communicated to him. If that be so, those remarks in if that be so, the SCR of 2018-19 would not have been considered by the authorities for denying promotion stroke SCP benefit to the petitioner. First up, the learned CGC does not dispute the fifth position. First up, however, the only issue that confronts the court at this stage is as to whether the petitioner would be entitled to the benefit of that promotion with retrospective effect as well as the SCP scheme. Mr. Deka seeks time till 27/4/2023 to seek further instruction and produce the records so as to resolve the aforesaid issue. Prayer allowed, let this matter be listed on 27/4/2023 as a fixed item. You come prepared, we'll dispose of the matter on that day, yes.
may I please your lordship, in this matter, university affidavit is necessary, lordship.
Whose affidavit is necessary?
Uh, Department already filed their affidavit in opposition, lordship, but the university is not filed any affidavit, but it is necessary in this matter, lordship.
Who is appearing for respond number 7?
I have the instruction, lordship.
All right, Miss
A Begum.
A Begum is present on behalf of the petitioner, Mr. A.K. Datta Lana CGC. is present on behalf of respond number
1 to 6 mile.
1 to 6. Mr. Dew Permanu, learned counsel for the respond number 7, submits that he has received instructions and therefore be granted 3 weeks time to file affidavit. Prayer allowed. Let this matter be listed again after 4 weeks. In the meantime, affidavit of the respond number 7 be positively brought on record.
Deeply.
This matter is pertaining to engagement of assistant branch postmaster. On the last occasion, your lordship has said that there is a similar issue. And your lordship has passed a note. Lordship, I have found that. To be honest. That matter is slightly different to my case. That was relating to compassionate appointment, and my case is relating to direct engagement. Issue was same, that is the local language issue.
Yes. Yes, what do you have to say, Mr.?
Lordship, here is the case, little bit different from the one Lordship had decided earlier. Here is a case where he was supposed to indicate which is the local language that he had appeared for. The apparently the document issued by the authority does not indicate whether it was Bengali or Assamese. Now, on the date of verification, it was on 8th. He still could not produce it. It was verified on the 8th itself. And the certificate that he got, that your Lordship will find at page 57 of the writ petition.
Yes.
Your Lordship will note the date. This was something which he got after the verification process was over, Lordship. Now, since it was verified on 8th and it was an online verification, it was closed on that day. And this is a certificate
Verification was completed when?
on 8th.
8th of August.
Yes, Lordship. Page 55.
He is from which district?
My lord, this is from Lordship, Kasa district. My lord, what happened, Lordship? Before that, on the day of filing my online application, Lordship, I have made it clarified. That is, your Lordship will find at page 38. 38.
No, what is the document you have produced before 8th of August?
Yes, Lordship, that is page 15.
Page 15.
My lord. My lord, serial number 2. Here, Lordship, MIL is Assamese and Bengali. There is no tick mark. Only on that ground, Lordship, my candidature was rejected. That is page 55.
It will be, because how will they figure out?
But in fact, Lordship, I have clarified that position that my MIL was Bengali. That is, your Lordship will find at page 38 at the time of filing my application, Lordship.
No, Mr. Khan, you see, we will only examine whether they have treated your client in an unfair and arbitrary manner.
My lord.
We are not concerned whether he gets selected or not. That's none of our business.
Absolutely, yes.
They are saying that the documents you submitted did not clearly indicate what was the local language or whether he was proficient in the local language.
My lord.
You submitted a document, but it was after the date of verification.
My lord.
So obviously that cannot be taken.
My lord, obviously.
Then what can be done here?
My lord, what happened, Lordship? On the day of verification, Lordship, I made clarification that my MIL was Bengali. And in fact, Lordship, my page 38, Lordship, that is the application submitted through my Pro Online. I have made clarification, Lordship. Page kindly, Lordship, page 38.
Yes.
Page 38, last table, Lordship. Subject, marks, grade points, Lordship. Here, general science, social science, English, then Lordship, MIL. MIL is Bengali, Lordship. I got 95 marks. That is, I have made clarify.
So have the posts been filled up?
In terms of interim order, Lordship, one post is directed to Vicat Becker.
He appears to be having a good career, 96, 97.
That is, I do admit, Lordship, he has got good marks in Bengali, but
No, not only Bengali.
others also.
96%, 97%.
Yes, Lordship. Now, Lordship, this
And
is
he has also done Sanskrit.
Lordship. Now, here is a case, Lordship, where on the date of verification, there ought to be some, because this is something he has uploaded that has to be verified. On the date of verification, if he's not with the particular document, this is his statement at page 38.
See,
but that has to be
online business, these are very new things. People are trying to come to terms.
otherwise, Lordship,
People are trying to come to terms with this.
Because my instruction is, Lordship, since it was verified on 8th and it was done online, thereafter it is closed. Manually, Lordship,
Where is the order to keep one post?
Madam, pace, order detail, Lordship, 2/9/2022.
Post is assistant branch postmaster.
My lords.
Petitioner belongs to OBC.
My lord. The certificate is also, Lordship, annexed.
And local language for Kachar is what? Bengali.
Bengali. That 17 is the OBC certificate.
Heard Mr. M. Khan, learned counsel appearing for the writ petitioner. Also heard Mr. R.K. Dev Chaudhary, learned Deputy Solicitor General of India, appearing for the respondents. Full stop. The writ petitioner hearing had submitted his application for he was a Gramin Dak Sevak.
My lord.
The petitioner herein was serving as a Gramin Dak
No.
Sevak. Then
Newly, Lordship, appointed.
fresh. These
Fresh.
are called GDS, Gramin
Fine.
Dak Sevak. But the post is branch postmaster.
That is under the Gramin Dak Seva.
Had applied for the post of assistant branch postmaster under the Gramin Dak Seva in response to the advertisement dated 17/8/2022 issued by the authorities. Full stop. As per the advertisement, the candidate would have to show certificates in support of his or her claim in respect of a claim of proficiency in the local language. Full stop. Since the petitioner had applied for the post in the district of Kachar, in respect of which the notified local language was within quotes Bengali, hence the petitioner was required to produce documentary evidence to show that he had proficiency in Bengali. Full stop. The petitioner had submitted online application along with the mark sheet and other documents. However, in the mark sheet issued by the Assam Sanskrit Board, it was not clearly indicated as to whether the MIL of the petitioner was Assamese or Bengali, although both the subjects were included in the table. Full stop. According to the authorities, since there was no clarity as to whether the petitioner had proficiency in Assamese or Bengali, hence he did not meet the qualification norm, eligibility norm as such local language is concerned. Full stop. The verification of documents took place on 8th of August 2022. Full stop. On 12/8/2022, the petitioner obtained a certificate issued by the Pradhan Adhyapak of the school wherein he had studied, which goes to show that the MIL of the petitioner was Bengali. However, since that certificate was produced after the date of verification was over, the same was not taken into account. Full stop. Aggrieved thereby, the petitioner had approached this court by filing the instant writ petition stop by the order dated 2/9/2022 passed by this court. An interim order was issued directing the authorities to keep one post vacant. Accordingly, the post of one post of assistant postmaster in the district of Kachar has been kept vacant. Full stop. There is no dispute in this case that the petitioner had studied in a school by offering Bengali as MIL. Full stop. He had also studied the course of Sanskrit. Full stop. From the documents available on record, it shows that the petitioner had scored very high marks in almost all the subjects he had studied. Full stop. Therefore, there can be no doubt about the fact that the petitioner has had a brilliant academic career. Full stop. The question, therefore, would arise as to whether merely because of a mistake on the part of the authorities in clearly indicating as to which was the MIL of the petitioner in the mark sheet, should he be made to suffer? Full stop. The system of submitting applications online is comparatively new in this part of the country. And therefore, if there was any delay on the part of the petitioner if there was a reasonable delay on the part of the petitioner to obtain clarificatory document, it cannot be held against him to deny the benefit of a recruitment process if the petitioner is otherwise found to be eligible. Full stop. Since there is no dispute in this case that the petitioner had in fact offered Bengali as MIL, and that is the notified language, local language for Kachar district. Hence, I am of the considered opinion that the petitioner has made out a good case for issuance of a writ of mandamus in his favor. Full stop. This writ petition is therefore disposed of by directing that subject to fulfillment of all other eligibility norms and conditions of the advertisement, the authorities may consider the case of the petitioner for appointment as the assistant postmaster by
In this matter, I am appearing on behalf of Mr. K. Gogodanat Chief Lordship. Lordship, as per the instruction, Lordship, the affidavit is being sent for vetting, Lordship. So at 3 weeks time, we have to find that. They have not filed their affidavit.
Mr. Bezbova is present on behalf of the petitioner, Mr. Tahvildar.
Lordship.
Learned Counsel appearing for the respondent submit that the affidavit on behalf of the department has been sent for vetting, and therefore 3 weeks further time be granted for placing the same on record. On the request of learned counsel for the respondents, this matter is directed to be listed again after 3 weeks.
Obliged.
Please, your lordship. My lord, order dated, my lord, 3/7/2022
23/11/2015 is yet to be complied regarding the case of the petitioner, my lord. Matter relating to pensionary benefit.
Pension 56.
Sorry, ma'am. Sorry.
The case, my lord, regarding the promotion. One, we have been filed an affidavit in opposition by the petitioner. That in opposition, it is informed that the respondent number 5, who has been appointed, with a fake certificate, he was fake certificate by filing a fake certificate fraudulently in collusion with others, take the appointment. That in the additional affidavit we have been made in this, my lord, statement, paragraph number 5. If your lordship goes to this.
This matter is finally to be disposed of.
Yeah.
Huh?
Lordship, otherwise pleadings are complete, my lord. We have
Pleadings are
filed-
complete.
The pleadings are complete. That one, we have been mentioned in here, my lord, that one fake certificate has been filed by the respondent number 5.
That copy, I am waiting for the copy is not been served on me.
No, we have been filed. We have been originally served additional affidavit. That at paragraph 9, we have been mentioned in here. That may be clear up, my lord.
You are appearing for respondent number 5.
I have not been served with the copy. That's why I am not aware of the fact.
Copy of what?
This is an additional affidavit.
Additional affidavit. We have
Additional affidavit dated.
that is additional affidavit 35/2022, my lord.
It is dated 27 April 2022. It does not be served.
Sorry, 27 April.
27 April 2022. One is 27/22 and other is
35/22.
35/22. That has not been served on me, my respondent number 5.
So you have not received 35/2022.
Two affidavits. One additional affidavit, two additional.
I mean, don't the price is there. This is there only. Self and serve, my lord. On today.
I have taken this from the.
Heard Mr. B.N. Sharma, counsel appearing with the petitioner, also heard Mr. Deenath, government advocate Assam appearing for the respondents 1 to 4 and Mr. S. Bora, learned counsel for the respondent number 5, who submits that a copy of the additional affidavit, copy of the affidavit dated 27/4/2022 and 35/2022 filed by the writ petitioner have not been served upon him. In view of the above and on the request of petitioner's counsel, this matter is directed to be listed again on 4th of May 2023 as a fixed item. The copies of both the affidavits be furnished to Mr. S. Bora within 2 days from now.
Phone number to kindly do. Phone number to.
But the signed copy I have received. I'm filing it today. Kindly.
You will serve copy on her.
No, I'll just have within the. Within
Get
the
the
course of
copy
the.
next week.
Yes,
will
that's
post it. Heard Ms. B. Gohal and counsel for the information. Also heard Mr. D. Nath, senior government advocate Assam, who submit that affidavit on behalf of the department will be brought on record during the course of the day
Yes.
by serving advance copy upon the petitioner's counsel. Mr. T.J. Mahantol and senior counsel
7.
is present on behalf of the respondent number 7. In view of the submission made by Mr. Nath, let these writ petitions be listed again in the next week as fixed items. In the meantime, the respondents counsel to file affidavit within 2 days from today.
Lordship.
But orders,
My lord, here is 4 points only. My lord. First thing, my lord, I was the secretary of the VDP for last 5-6 years. My term was expired. Then the second meeting was called at
is
village.
it ready for disposal?
I was, yes.
Is it
SP has
ready for
filed a
disposal?
VDP. Lordship. SP has filed a VDP.
Second up, yes.
Yes, what is item 30?
No, my lord, thing is this, my lord. The petitioner was earlier working as secretary of Bidapur VDP party. His term was expired. Thereafter, as per rule, my lord, they have to constitute a new committee. In the new committee, my lord, I was selected by the village committee as the secretary. But that was not disclosed by their earlier affidavit. But when this Honorable High Court asked the other side to produce the record of the meeting, then they filed a second affidavit. In the second affidavit, my lord, it is very much clear that I was selected for that post, but as per the letter of the MLA, my position has been changed. Now, I am higher secondary pass, and the private restaurant read up to class 7. He cannot maintain record as per rule, my lord, VDP rules, my lord. We have to maintain records, whether outsiders come or knows who has gone outside, who has come inside. All these things have to be recorded. He has no qualification at all. He is read only up to class 7 level. So, my lord, kindly see the second affidavit filed by SP. That is our case. He has admitted that yes, he was appointed as the secretary, and every person was present there. Kindly see, my lord, page 50. Page 50 of the second affidavit of SP. So only at the instance of MLA, I was not attending. MLA has no role here. Only village organization, circle organization, and this SP and OC has a role.
So that you lodge a protest against the MLA, what can this High Court do about it?
No, High Court.
Appointment, reappointment, these are not our matters.
No, that was, question was raised, that has been settled by the order by my Lord Justice Budor Borua, held that this code, this writ petition is maintainable. Because there is no other forum. And that I have annexed in my affidavit in reply. Kindly see my affidavit in reply, page 54. Sorry, lost it now, sorry. My order of my Lord Justice Budor Borua's order is there. There is this question that was answered, it is maintainable. Para 7 of the order dated 29/6/22. Para 7. And my lord, they said that my term was expired. Yes, that is true. My term has been expired. Thereafter, up to 45 years.
So you want the appointment order to be issued by the court or?
Lordship may kindly direct the SP to appoint me. That is my humble prayer.
Please try it somewhere else. This
because
kind of
my lord-
order cannot be passed.
Because to set aside the order of private restaurant.
This order, read court cannot pass this order. You try it elsewhere. I'm not. These are matters of, in the domain of the executive. They may be right, they may be wrong.
But if they commit wrong.
Listen, Mr. Mahmood, know the law. It will help you and at least the others present here. Merely because some orders are passed here and there, that doesn't become the law. Justice is to be dispensed in accordance with law.
Yes.
While exercising jurisdiction under Article 14, the court is to see whether a discriminatory and unfair treatment is being meted out by the people in power in administration, executive, or whatever legislative, which tends to discriminate one against the other. In other words, whether the equality of law is violated or not. The reed courts are not sultans. Judges are not to act like sultans. That give him this, give him that. That's not the idea. So you are telling me that your term has expired, you sought reappointment, somebody is coming in the way, so a direction
No, I
should
am
be
not
issued.
seeking, but people selected me.
Go to the people's court and vote that MLA out of power. If you think that he has done something
It is
wrong.
there, man.
This is not for this court, read court to get into.
Then
all
I'll
this.
say your lordship, that will be fixed on that point.
Hmm?
That will be fixed next after vacation.
Yes. These are not matters. We are not here to issue appointment. If we find that somebody has been wrongfully denied and
That is
somebody
my
has been,
case.
huh?
I was selected, public selected me,
Hmm,
and committee was constituted.
hmm,
Thereafter, MLA wrote a letter
hmm,
at the behest of 8 persons,
Hmm.
whereas 208 persons supported me.
Hmm.
Only 8 persons filed a petition before the MLA
hmm.
that his selection is illegal.
This is a completely political process all throughout.
So,
Your selection is political. Your obstruction is
no,
political.
no, sanction of politics, it was done by Gaon Sabha. That
Yeah.
is the law, man.
Yeah.
Gaon Sabha selected me as the secretary. I had to be appointed. In the meantime, some person entered, MLA wrote a letter to SP, then SP, without showing any reason.
So is that not a political exercise?
That is why I am before lordship.
Mr. Mahmood, what to do? Issuing mandamus in these matters is creating problem. Who says there is no forum? Who says there is no forum?
There is.
These matters can be taken to the, complaint to the concerned minister.
Yes. Minister.
Then why are we electing them? And if they think that he is not the right man, he is the right man in the political realm, that is the answer.
Better come after vacation. Let me satisfy your lordship. Or the alternative forum is there, that on that point I will say.
No, but if there is no alternate forum, the read court will go to any extent.
That is the law, my lord. If there is no forum,
What is
party
that?
cannot be left remediless.
Show me the law.
Party cannot be.
Supposing you are not satisfied with the verdict
Yes.
in an electoral process where a particular party is brought to power.
Yes.
There is no forum to challenge. So you'll come to the read court and say that declare them the election illegal.
On that point I will satisfy you.
On the request of Mr. M. O. Mahmood, Land Council of the petitioner, this matter stands adjourned for 2 weeks. Mr. J.P. Goswami, additional senior government advocate Assam is present on behalf of the state. Please examine it, Mr. Mahmood. You must make submissions which is in consonance with the constitution.
Earlier, this honorable High Court, by order that is 23.
What is the principle?
It was held that read petition is maintainable.
On what principle?
What principle? Because no forum other.
Why no forum? If the MLA interferes, these two
No,
got to be.
MLA did totally as an MLA, but without following any rule. He has.
Take it to the public forum. What is your right?
No right, if you have no right, legitimate expression I do have. Because people have selected me. And that is the law.
Is that your submission? Legitimate expectation.
I will say.
No, is that your submission? Then let me dictate the judgment just now. There are at least 50 judgments where it has been held. Legitimate expectation cannot be enforced through a writ. It is only a protection against arbitrary.
But I have also judgment, the legitimate expectation is as good as fundamental rights. I have also those several judgments I do
And
have.
it can be enforced.
As good as fundamental right.
Therefore, it can be enforced.
It is enforceable right. As per our Honorable High Court order,
You show me that judgment.
when Justice N.S. Singh.
Show me that judgment.
Today I have not brought, but if you lost it, that is why I say that I will satisfy your lordship.
You come back, the day you get a judgment where law is laid down that legitimate expectation is enforceable by a writ of mandamus. You come anytime and we'll have the matter listed. Please go back. Okay, Mr. Mahmood.
In this matter, my lord, I was requested to appear, we have a PNRD department, my lord.
Order has been complied with.
Not complied, my lord. They are taking considering the cases of the petitioner, my lord. And finance department.
What is the direction?
Direction to verify and consider, my lord. To consider, my lord.
You want some more time?
My lord.
So take down heard Mr. R.S. Sohan,
On behalf of my lord, M. Islam.
heard learned counsel for the petitioner, also heard Mr. S. Dr. Learned counsel for the respondents who submit that the steps for compliance of the court's order is under process and therefore 4 weeks further time be granted. In support of his above submission, Mr. Datta has produced copy of the written communication dated 4/3/2023 and 4/3/2023 issued by the Under Secretary, the Government of Assam, Panchayat and Rural Development Department. On the request of Mr. Datta, this matter stands adjourned for 4 weeks. Copies of the communications dated 4/3/2023 be retained in the case record.
Highly obliged.
You are for whom?
What is respondent?
Petitioner is absent. Yes. You have been waiting since morning. But now the petitioner is absent. What to do? Mr. Das,
Well, this case is regarding payment of gratuity. It's a dispute of group of work and some persons who has not received notice, maybe type of, fix for it.
so what is to be done today? Tell me. None appears for the petitioner when the matter is called up. Mr. S. Das, learned counsel for the respond numbers 11, 13 and 18 is present. The remaining respondents are absent. In view of the above, this matter stands adjourned for 4 weeks.
What was called for?
Perceive my seniority on legs in court number 10. Matter be possible.
Which is the order which was not complied with?
Page 9, Lordship. Operative part is at page 11.
Yes. What has happened? The order has been complied with.
Actually, my seniority on legs will be coming after 2 minutes.
No, we cannot wait. So what has happened? He has not been allowed to participate.
No, Lordship.
Participate in what?
AB for UB constable, Lordship.
When was that held? Who is the senior?
Mr. Dinath.
Call him. I'll wait for 5 minutes after that personal appearance.
Okay.
Lordship, in this matter, the petitioner is claiming for arrears salary as well as the non-practicing allowance, my lords. From on the last date, my lords, the arrears salary was paid, my lords. Regarding the non-practicing allowance, my lords, I have received an information that the petitioner never applied for it. Whether the non-practicing allowance was added in the arrear payment, my lords, that was the query which the court had forwarded, my lords. Upon the query, my lords, it was found that Mr. Bohantol, the petitioner, he did not apply for the non-practicing allowance, because of which it was not allotted.
So lordship, if
So if he applies, will you give it to him?
consideration would be, my life is entitled from 1996
You
lordship.
apply, then we'll close it.
May,
You apply for the non-practicing allowance.
Lordship, may I make my submission also?
Be very brief, yes.
Lordship, actually, I had applied.
Hmm.
And because I did not get every year a new pay slip, in the next year's pay slip, the allotment of the NPA comes. But I never got any pay slip.
All right, so you make a fresh application
Lordship,
now.
I have the instruction. Let him make a fresh, it will be considered.
Give me the instruction. You make a fresh application
Yeah,
now, they will consider.
It will be considered, my lord.
Lordship, there is an IA. I have some.
Now lordship, through the.
What is the IA for?
I have filed an IA.
Now,
For the
asking
interest,
for fresh mandamus, my lords. They're asking for interest from my lord. That was not considered in the contempt order, my lord.
So
Lordship.
that can't be done in a contempt case.
I'm asking for lordship, that is.
Mr. Laskar, those things cannot be taken up in a contempt case. You may not be aware of some technicalities.
So in the, I was asked to give a representation also. I have filed a representation. In the representation, it was there. In the representation, it was there.
Presentation it may be, but it is not there in the read petition.
It was there in the writ petition, because in the writ petition, I had filed an IA and an additional
All
affidavit.
right, you make an application for non-practicing allowance.
Yes, my
and
lord.
they will consider. We'll postpone it by 4 weeks.
Lordship.
Dr. Basanta Laskar is present in person. Mr. A. Chalia, learned counsel appearing for the respondent, submits that the petitioner has already been paid his outstanding area salary. Insofar as the prayer for non-practicing allowance is concerned, according to Mr. Chalia, the petitioner has never made a proper application on that behalf. First up, by producing a copy of the written instruction dated 5/4/2023, issued by the Director of Medical Education, Assam, Mr. Chalia submits that if and when the petitioner makes an application supported by documents, proper documents of seeking non-practicing allowance, the same will be considered in accordance with law. First up, responding to the above, Dr. Laskar submits that he be granted 7 days time to submit an application for non-practicing allowance. First up, prayer allowed. Let this matter be listed again after 4 weeks. A copy of the order dated 5/4/2020, written instruction dated 5/4/2023 be retained in the case record. You please file an application. Interest part, we'll see.
Yes.
If it is there in the order, fine. Otherwise, it will not be given. It cannot be given. By a representation, the court's order scope cannot be expanded. That's the law. You may have to file a fresh petition for that. If you want any legal help, tell us, we'll provide you. Free of cost, we'll provide you a legal help. All right. Yes, next matter.
What's a fixed date, please? Fixed date, Lordship.
After 4 weeks,
Date.
as a fixed item. Give a date after 4 weeks. After 4 weeks, give a date. Give a date. You have received this 82 lakhs something, you have received that. That you have received.
Yes, Lordship. 15th. No,
15th May, yes. Yes.
This is an application for violation of order dated 27/10/2021 at page 35, your lordship. The direction to regularize the services of the petitioner and to pay retention or to issue order retention and to pay the area salary, my lord. Operative portion is at page 37, my lord. Para 4.
Lordship, in fact, the matter is before the finance department now, Lordship. We have in fact written to the finance department, Lordship. In fact, Lordship, I have submitted a status report before Lordship, probably before Lordship.
What is the final direction?
To
Lordship-
regularize the service to pay. to
Lordship has
issue
to see,
order
Lordship,
retention.
Lordship has to see, Lordship, page
Lordship, prior to
initial
that-
order, page 18, Lordship.
Lordship, yes, page 18, the second round of litigation, there are 2 orders of this honorable
orders.
court, my lord.
Lordship, may kindly see page 21. Paragraph 7, Lordship, onward, Lordship. Mr. R. Borput, the Learned Standing Counsel appearing for the Finance Department submitted the case of the Jitendra Kalita, so and so, full bench of the court clearly held that there should not be any regularization in terms of the office memorandum date so and so. He submits that subsequent to the division bench of this court in the case of State of Assam versus Upendas and others reported in so and so, also held that the casual employees do not have the right to claim regularization. He also submits that the petitioner may have been erroneously not regularized at the relevant time, but it is now too late in the day to regularize him in the service in view of the various judicial pronouncements. Under the circumstances, he submitted the writ petition be dismissed. Lordship, however, Lordship, the writ petition was allowed, Lordship.
Lordship, fact is different. Issue of regularization, the order regularization came in my favor. Benefit was given to somebody else with the same name, Your Lordship, Bhuvan Chandra Das. All the as on that he is enjoying the benefit, I have been deprived with 1493. Prior to 1493, I was working, Your Lordship. There's order of regularization which came in my favor, Your Lordship.
Page 22, page 9.
Where is that order given to Bhupen Chandra Das?
Lordship.
Page 22, para 9, Lordship.
So there is a direction to regularize his services.
Lordship, for regularization, Lordship, we have placed the matter before the Finance Department. Without the approval of the Finance Department, Lordship, we cannot regularize.
When did you?
Lordship, in fact, Lordship, in my status report, Lordship, it is clearly mentioned. Accordingly, the file was again endorsed to Finance EC Department on 9/9/2022, requesting for a concurrence towards regularization of the petitioner in compliance of the Honorable High Court's order dated 22/2/19. However, in its return endorsement dated 22/9/2022, Finance EC2 Department has conveyed the view that Honorable Guwahati High Court in its order dated 8/6/2017, passed in writ appeal 45/2017, so and so held that workers, MR and similarly placed workers are not entitled for regularization with consequential benefits like pension, etc. So they have returned the file, Lordship.
Lordship, prior to that, order dated 1/10/2020, 26, order prospect to retention was given to me for a particular period, my lord. Your Lordship may kindly have a look, my lord.
Mr. Chalia, what is this? What is the order of the court?
Pursuant to this, my lords, there were certain development where the Finance Department again asked the Irrigation Department to provide us with some certain details for which we can reconsider the case of the petitioner, my lords. Here in this Lordship, some time may be granted so that we can come up with some clear information whether whether we have received the clarifications or not, my lords, and what is the status, my lords, because there is.
Lordship, I am suffering a lot.
Lordship, I am asking for a short date, my lords, so that I can satisfy the petitioner also, my lord.
What do you want to be done today?
My order to be complied with.
They are not complying with what to do.
My lord.
They are not complying. We have to find a way to do it.
Lordship, I'm
2 weeks
seeking
time you.
Lordship, Lordship,
Immediately after the holidays.
yes, Lordship, I will get it.
We are senior counsel estate by Ms. So-and-so. We brought a counsel for the petitioner. Also heard Mr. H. Upadhyay, learned counsel for the respondent.
Lordship, I am for.
Respondent numbers
Hi. Oh,
5, 7 and 8.
Lordship.
Is it 5, 7 and 8?
No, 2,
You
2,
don't
3.
even know who you are representing.
Lordship, I am for 3.
Huh?
I am for 2 and 4, Lordship.
2 and 4 who submit that the file, the relevant file is now lying with the Finance Department. Mr. H. Chalia, learned counsel appearing for respond numbers.
Respondent 3.
Respond number 3. Placed for 2 weeks time to obtain instruction and appraise this court as to what steps have been taken by the Finance Department to approve the file of the case of the petitioner. List the matter again on
Short date.
on 10th of May 2023. Yes.
May I please, Your Lordship?
Yes.
Case 8 is the order of which was non-compliance, my lord.
I have issued notice, but as per office note, my lord, notice was not served.
Then you take fresh steps. On the request of Mr.
HM.
HM Learned Counsel for the petitioner, leave is granted to the petitioner to take fresh steps for service of notice upon the respondent by registered post to the AD. Steps within a week from time,
All right.
making the notice returnable in 4 weeks. Yes, Mr. Nath.
But the records given by the SP, ultimately they clarified that this is the records. They have no further record now. So in fact, the process was held up. Process was conducted by online, Malon, and it was an online process. And in the online process, Malon, as per
No,
the
there is the order of 10th of February, 10th
Yes.
of November 2021.
Yes, Malon.
Whereby it was ordered that they should be allowed to participate in the process.
Yes, Malon.
Then
Malon,
what happens?
Malon, to that effect, Malon, we have filed an affidavit, Malon, Lordship, that kindly take up our affidavit of the SP, Malon. In the Lordship is holding the contempt petition, Malon.
Yes, yes.
Lordship. But on 10th of kindly see Malon, para 4. On 10th, the order was passed. In fact, the 9/11/2021 was the last date for the Nalbari district. Kindly see Malon, para 4. The recruitment rally of AB UB constable was held based on advertisement dated so and so. During the recruitment rally, any grievance or rescheduling test was done by the district level committee in Nalbari on receipt of applications received from the candidate where grievances on the grounds of rescheduling dates are mentioned. Accordingly, grounds are verified and applications are considered. In a similar way, the petitioner's application for rescheduling the date of PST PT was accepted and initially rescheduled to 20th of October 2021. Petitioner's second application along with the medical certificate is also accepted by the DLSC Nalbari, and the date of test was again rescheduled to 27/10/2021. However, on the date of the test, that is 27 October, it was brought to the notice of the DLSC Nalbari that the name of the petitioner is the admit card issued by the State Level Police Recruitment Board, Assam, in connection with the recruitment rally of AB and UB constable was Kumut Thakuria, whereas the name in the supporting documents including HSLC pass certificate, HSLC admit card, mark sheet, caste certificate submitted by the petitioner is in the name of Kumut Kumar Das. The petitioner could not submit any reliable or authentic document to substantiate that Kumut Thakuria and Kumut Kumar Das are one and the same person. Hence, after thorough verification of the documents submitted by him, his candidature was rejected. The deponent respectfully states that on 12/11/2021, a instruction was received from the government advocate to submit para-wise comments by so and so, and accordingly, para-wise comment was submitted. Then kindly, my lord, come to para 7. The Honorable Court order dated 10/11/2021 allowing an application dated 18/11/2021 submitted by the petitioner was received at the office of this SP Nalbari on 29/11/2021. It is to be mentioned that as per schedule provided by the State Level Recruitment Board, the recruitment rally in the district concluded on 6th of November 2021, which was prior to the Honorable Court order dated 10/11/2021. In addition to this, it is also to be mentioned that the recruitment is conducted by the State Level Recruitment Board and the District Level Recruitment Selection Committee. Neither has any role in the subsequent selection process, nor can review the result of the PST even after completion of the PST event. So, in the record given by the SP, I have handed over there the date, the last date, including the buffer period, 3 days period is up to 9th of November 2021. Therefore, he could not be considered, my lord.
What to do now?
Buffer date was 9/11/2020.
It was not a willful disobedience.
All the process was not completed. It is only the
But district level.
This is now over. The recruitment process is over. What can be done now? Nothing can be done. The only thing can be that the officer can be punished. But it does not appear to be a willful disobedience. You have to leave it at that. You have to leave it at that. All right? Yes. Heard Miss N. Hassan, Learned Counsel.
F in does.
F.
In
Intaz, Learned Counsel for the petition. Also heard Mr. D. Nath, Learned Counsel appearing for the respondent, alleging willful violation of the order dated 10/11/2021, passed by the Learned Single Judge in WPC number 5935 of 2021, whereby a direction was issued to allow the petitioner to participate in the process of recruitment for the AB constable. The instant contempt case has been filed. First up, by filing affidavit dated 24/5/2022, the sole respondent has brought his stand on record. First up, after perusal of the same, I am of the view that this is not a case of willful disobedience of the order of this court. Moreover, the process of recruitment of AB constable is over long back, and at this stage, there is no scope for the respondents to consider the case of the petitioner. In view of the above, this contempt case stands closed.
There is a connected writ petition, my lord. A connected writ petition is also there.
What is the writ petition about?
Writ petition here, my lord,
For non.
Add one more line. It also appears that
her
there is a
the
serious
petition
dispute
has,
about the name of the petitioner. In as much as in some places he has introduced himself as Kumud Thakuria, and in some cases as Kumud Kumar Das. Full stop. Then you write, after going through para so and so and so and so. Yes. What is the writ petition about?
Lordship, challenging the advertisement of order, so rejection for rejection, Lordship. Challenging is rejection, Lordship, to appear in the UBAB constable post, Lordship. This petition is done.
Now, how can you participate? It is over now. Recruitment process is over.
yes, my lord, appointment has been made.
What remains in this?
Para 8 of the affidavit, we have said, my lord.
Recruitment process is over. And no post has been kept vacant. So how can you be, what can be done now? You can't be allowed to participate now. Is it not?
It means you had some other relation.
Huh?
It means-
All right. On the prayer of Miss Counsel and counsel for the petitioner, this matter stands adjourned for 6 weeks. Mr. D. Nath, Learned Senior Government Advocate Assam, is appeared for the.
Lordship.
Item 44.
My lord.
Item 44.
As per the lordship order, my lord. His claim was examined and speaking order was passed, my lord. And speaking,
Rejecting is prayer.
With all benefits cannot be granted, my lord. That's the ultimate conclusion, man.
Let them file a affidavit.
No. You challenge this order if you want. We'll close it. Mr. Your name, please?
K. Pujari.
Huh?
K. Pujari, lordship.
Mr. K. Pujari, Learned Counsel is present on behalf of the petitioner. Mr. S. Bora, Learned Counsel for the respondent, has produced a copy of the order dated 30/3/2023 to submit that the request of the petitioner in terms of the order of this court has been considered. But many of his requests could not be granted due to the reasons maintained in the order. First of, if that be so, it cannot now be said that the order of this court has not been complied with. The petitioner would, however, be at liberty to assail the order dated 30/3/2023, if so advised. With the above observation, this contempt case stands closed.
Item 45.
Yes, have you understood? You have not understood?
Yes.
Yes.
Lordship, keep that order in the record, my lord.
A copy of the order dated 33/2023 be retained in the notes. Yes, record.
Item 45.
In this case, madam, today I have received instruction for appearing on behalf of the respondent number 2. But still, let my lord, affidavit is yet to receive, my lord, from the director, my lord. And here direction was for reconsideration review medical board.
Verbally, I have instruction that it was held, but the outcome, I have to tell. The petitioner's counsel is present. Mr. K.K. Parashar, learned counsel submits that he has received instructions to appear on behalf of the respondent number 2 in this case, but be granted 2 weeks time to file wakalatnama as well as affidavit on behalf of the said respondent. Taking note of the prayer made by Mr. Parashar, this matter stands adjourned for 2 weeks. 46 was the same, my lord, out of same common order. 46 same order, list along with this. Yes. Much of
My lord, in this case, my dear lordship, can it take up the miss case, my lord? I am seeking leave of this honorable court to declare the result. Because there is a order that my lord, without leave of the court, result should not be declared.
what results of what?
Result of selection of MVI, motor vehicle inspector. There,
I am led by my senior Mr. Yukena. Can it be taken after some time, Lordship?
Tomorrow we'll take it up.
tomorrow.
Tomorrow. This is the, on the request of Mr. MP Goswami,
Sharma.
MP Sharma and counsel for
Let it be day after tomorrow.
list this case again day after tomorrow as a fixed item. Mr. T.J. Mohantal and senior counsel is present on behalf of the APSC. And Mr. Miss M.D. Bora for the transport department. Day after tomorrow.
My lord, his case is IH regarding lordship substitution of lordship 48. 48 IA. Before lordship proceeding lordship. Before lordship proceeding lordship, so I may be allowed to lordship correction of the lordship applicant name lordship. It should be lordship Swagata lordship. Lordship by try to do a mistake lordship. Instead of yes, lordship, it is.
Then you correct it. You can't do it like.
By
that.
hand, lordship, your lordship permit me, lordship. Lordship, I have to file an amendment petition,
You
lordship.
can send me a SMS then. I'll keep it. Legal matters cannot be treated so.
Lordship.
You follow the procedure and correct it. Mr.
B. Malakal.
B. Malakal and counsel for the applicant submits that there is a mistake in the name of the applicant and therefore he be granted a week's time to rectify the same by following the due process. Prayer allowed. List this case after the rectification of the name of the applicant is carried out in this item. You approach the registry, they will tell you how to do it.
I'm sorry, Lordship, in item 47, there is an interim order that may continue.
Interim order passed earlier to continue till then. Yes.
Obliged.
May I please, lordship? Lordship, the matter pertains to suspension, lordship. Lordship, may kindly have a look last order, lordship. 24-3, lordship.
Lord, I can hear myself.
No, it's a big order. Yes, what is your instruction?
Lordship, so far, Lordship, so we sent a letter, Lordship, but the instruction received by the revenue department.
On 12/4, my lord, it was, my lord, the petitioner asked to appear in the, before our concerned officer for his, recording his statement. On 12/4.
Day after tomorrow.
So what, there is some inquiry going on?
Yes, Lordship.
Are you aware of it?
Lordship, my humble submission.
Yes or no? Are you aware of it?
I am not aware, Lordship.
You are not aware.
I am not aware, Lordship. Lordship, because I am under suspension since 9 months, Lordship. So my only livelihood, source of earning livelihood was to register by doing registration of marriage, Lordship. And as I am under suspension since 9 months, I have to work in different places to earn my livelihood, to support my family. So at that relevant point of time, I was not there. But when the person contacted me to receive that, I was not there, Lordship.
Yes.
When I came to know from my family, Lordship.
He is our Lordship.
Later.
He is our Lordship, and day after tomorrow, Lordship, he have to take the give the statement before the authority, Lordship.
Lordship, may kindly
Regarding the
page
inquiry.
39 for a moment, Lordship.
Have you received notice to appear day after tomorrow?
I have no instructions, sir.
No, Lordship.
I have no such.
So
instructions.
far, Lordship, my instruction, Lordship, the notice issued, Lordship, but he was not found in his place, Lordship. Although the family member, Lordship, the person concerned.
Listen,
Yes,
answer to the question. You are going all over without. What is the proceeding you have initiated against him? On what basis? Produce the entire record on 20th. Heard Mr.
A. Islam.
A. Islam, learned counsel for the petitioner, also heard Mr. J.K. Goswami, learned government advocate Assam appearing for the state, as well as Mr. J. Hande, learned standing counsel revenue and disaster management department. After hearing the submissions made by learned counsel for both sides, this court is inclined to examine the record pertaining to the alleged inquiry proceeding initiated against the petitioner. Mr. Goswami to therefore produce the relevant record on 20th of April 2024-23, failing which the concerned officer to remain personally present.